going to bring the meeting back to order. We are, at the outset of the meeting, we had rearranged agenda items 5 and 6, so we are discussing item number 6, discussion and consideration of proposed statutory language regarding the veterinary student exemption, Business and Professions Code Section 4830A4, potential recommendation to the full board. So we've seen this before. This is language that we had discussed last year and had passed through this group and to the Vet Med Board and then to the legislature, where it got stopped because there were concerns and issues with paragraph B that's at the bottom of my report on student exemption. And so again, I've summarized in here kind of the debates, and the question ultimately as we try and create the student exemption is whether A, is sufficiently clear, is the consumer or the veterinarian offering an externship aware of the COE guidelines, and should those guidelines be referenced or identified in the Practice Act. So we do have the language A that at this point has not seemed to be disagreeable to any of the universities, the MDC or the board. B really was a restating of the COE, the AVMACOE Council on Education's accreditation policies and procedures for off-campus and distributive site learning. And it was almost word for word taken from that. I think that where we ran afoul of some folks was the use of the phrase memorandum of understanding and some anxiety that by putting this where we are, by putting this in black and white, basically, we are potentially opening the door for the legislature to amend that section and have different items fall under that MOU, and so it could have unintended consequences. That was that seemed to be the most vocal concern. And then the second thing that I heard was it's just not necessary. It's already in the COE, and so why would we restate what's already there? So with this stage of the game, I then offered at the very bottom of my 2-page report an alternative form of B, and our question is, to be or not to be, quite honestly, whether or not we need to have a B at all, or if we do, what do we want it to look like? We've got Dean Pascoe here, who was involved in these discussions and was part of a working group on some of this language a year ago when we were doing this, or 2 years ago when we were doing this initially too. So we'll rely on him and other members of the audience to help us as we work through this. Within the committee, any questions, comments, discussion at this stage? Yes, Dick?
I think from the beginning, B was just as much addressing students coming from other states as it was the in-state students, because you know, what can students from Iowa or Colorado do in this state? So I think that if they're doing the same activity that a Davis or Western student is going to be doing, then there needs to be a contract. The board needs to know if that student is just an employee or is there because of a defined program with the university, because this is a student exemption for a license. And if that's what it is, there has to be some type of paper trail or contract that acknowledges that. And so that's, I firmly believe we need B.
Other comments? Alan?
I have thought that if we simply, under B, and B, on the 1, 2, 3rd line, put a period, be in place, that wouldn't be prescriptive, or I don't view that as allowing the legislature to determine what is included in the memorandum of understanding. It just formally sets a requirement that you can't just shuffle the students off without having any expectations of what they are to doing or where they are really to be going.
And the counter to that is on the next page with the AVMACOE Guidelines. If you look at items 4 and 5, item 4, the off-campus site must be reviewed to ensure that the educational program is being delivered appropriately. And item 5, there must be a written description of the educational objectives expected to be achieved at the site and a mechanism for assessing the success of the educational process. So again, the schools have said, hey, we're accredited. This is part of that process. What you are doing is redundant. And I have countered, yes, but what we're also doing is adding clarity, because I'm not completely convinced that the supervising veterinarian in California is going to even know what the COE is. And so I'd like to actually bring Dean Pasco up here at this point and put him on the hot seat. Get him to help us understand at this point where we need to be with this issue so that we are protecting all of the classes of consumer that we're trying to protect.
And I'd like to clarify, I don't have a problem with the second page, which version of it, but I think we need one version of it.
Dean Pasco?
You're on.
John Pasco, School of Veterinary Medicine, UC Davis. Do you want to comment or you want to question?
No, I guess I would like you to help us navigate this. I mean, again, am I correct that the prevailing feeling of both schools, as you know it, is that really B is unnecessary?
I think that's a fair representation, yes.
Okay. So our concern is the student that we think that the compliance and understanding within the state schools is fine, but our concern is a student that comes from some school for an accredited university and has an externship program in California. How are we to know, and how are they to know, we the VMB, that they are following the COE guidelines? What guarantee do we have that all folks, the animal, the pet owner, the supervising veterinarian, and the student are protected?
I'm not sure you have that now, correct? So I don't know that I can give a really good answer to that, because the COE process, and the COE is the recognized accrediting agency for veterinary medicine by the U.S. Department of Education, is charged with assuring the quality of veterinary medical education, and then really inherently built into that, and the thing that determines whether a college is in compliance or meets the standard, the 11 standards of accreditation, is really focused on student learning and student safety. So they're the overarching objectives beyond the quality of veterinary medical education. Just from a historical perspective, the reason that this language that's in the COE accreditation policies came into being was with the development of Ross University initially, and then Western University, because they don't have on-campus teaching hospitals. And now we have Lincoln Memorial University in the same situation, in Calgary in Canada, which is also an accredited program. And so this was added to satisfy a number of objectives, not the least of which was anxiety within the profession about the quality of education that might be offered by those institutions. And so this was a much more prescriptive approach to ensure that the educational program, the learning objectives were spelled out, that there was actually a process to a contractual arrangement, if you will, between the institution and those sites where that clinical experiential learning was occurring. So it doesn't cover, if you look at number 6, it doesn't cover what we would consider, I think all of us understand, externships, which are sporadic learning experiences still part of the formal curriculum because the student has to complete those once they elect to do them. This language was intended specifically 1 through 5 for those institutions that don't have on-campus teaching hospitals. So I think that, in principle, when we first did this, our intent was to get A covered because the Practice Act didn't speak to students from any other school other than UC Davis or Western. And we knew, and it predates, probably a 15, 20 plus year history of concern about students from other schools of veterinary medicine that were actively engaged in externship experiences in California. And so A, I think, brought a lot of clarity to it, and it restricted it to students from AVMA accredited programs, accredited schools, as opposed to recognized schools of veterinary medicine. And so I think Western University in particular, and I'm obviously not deputized to represent them, but I think from Ron Terra's comments on behalf of Western University, I could fairly state that they felt very strongly that B was already accounted for in the accreditation process. It wasn't really needed to be spelled out again, and they had a real concern that this may open the door to the legislature to be a lot more prescriptive, and so that's where their concern primarily came from. Much of B doesn't apply to UC Davis, so it was sort of an issue for Western, to be honest.
So what was UC Davis's objection?
I guess it wasn't so much an objection as we felt that A covered what was needed. And I think, Anne Marie brought up in several meetings the fact that the student was also a consumer, and so I think part of her argument was that B helped protect the student as well. As I recall the discussion, there was that was at one end of it, and at the other end of it, the veterinarian is ultimately responsible, right? And so back to your original question, and I really don't want to muddy the waters on this, but I'm not sure B addresses the question you brought up originally, which is how is a veterinarian aware of that and what is their responsibility? I think the way the COE looks at it at the moment is the institution's responsibility to have that agreement. And yet the question you posed is almost the other way, which is if the board was investigating something here, their jurisdiction is the licensee, right? So then my non-lawyer approach to this would be that it would really be up to the veterinarian to make sure that they have a written agreement if B stayed in here. So it would shift the responsibility, or it makes it a mutual responsibility. Is that?
Yes.
Yeah, and that's, there's, my concern is a level of awareness by the supervising veterinarian who decides to open their doors. And I imagine that the schools understand what they're supposed to be doing. Do we need, this committee needs to decide, do we need the language that's in B for clarity for that supervising veterinarian, or do we feel that under the auspices of the COE, that the school is going to make sure that that written agreement is there and that we don't need that?
Dr. Quinbart, may I inject just a question here? I've heard supervising veterinarian over and over again, and it was part of your question. We're assuming that the supervising veterinarian is subject to the jurisdiction of the board.
Because
that's not the case necessarily at the University of California, correct?
They are now.
with the university licensure, they certainly are.
I thought they were exempt.
Not anymore.
So it is possible for the board to take action against a supervising veterinarian of the University of California. Is that right?
Ultimately, it will be.
Does the board have the authority to ask the University of California for its written agreement? Secondly, does the board have the authority to at least impliedly approve or disapprove that written agreement. If the board disapproves the written agreement, what action, if any, can the board take in regard to the University of California? I think that's kind of pinpointing the concerns of the board.
So that gets into a whole nother discussion about the board's oversight of the schools in the state of California. So if you look at the law in its purest form, it talks about the board recognizes accreditation, and that's true for most boards that issue licenses. It doesn't remove the board's authority to actually approve schools. Would we get into the business of doing that? No, and it would be irresponsible for the board to do that unless it had some special committee. We approve schools for RVTs. We don't necessarily do an independent approval for veterinary medical schools. However, the way the statute's written, we have the authority to do that. So in looking at, I want to clarify, and you brought up a very good point. The jurisdiction of the board is not going to be over the out-of-state institution. The jurisdiction over the board is going to be the practice that's occurring in California. And if you're creating an exemption in law, which this creates or changes the exemption, it's there now, it's just not well defined, then you're saying this is an exception to every other licensing provision that's currently in the law. So you're right. A clarifies what the exception is. B says, A essentially says, when you're doing this within the university, you can do surgery, you can do these other things, and these are the layers of supervision that is required of you, university. B says, you're not...
Correction, A covers everybody. It's not just university. It's every practice and every licensed veterinarian in the state of California.
Where it's formal curriculum.
No, the way I read A is that the student has to have completed that training as part of their curriculum, and they must be supervised by California licensed veterinarians. So it's incumbent on the veterinarian to establish that they've actually, the way I interpret this, it would be incumbent on Dr. Sullivan, if he had a student in his practice, to be convinced, satisfied, or otherwise that that student's completed that part of their curriculum.
But the only way the student is in fact exempt is if what they're doing is part of their formal curriculum. So that should not be mistaken.
Correct.
Okay. So this is part of the student's formal curriculum.
Correct.
Now then we're talking about a different model of education. We're saying, okay, where you're not on campus, you're somewhere else, you're doing off campus, or it's a distributive model. You have an exemption. But in order to qualify under that exemption, there are things that have to be met, where there has to be some agreement between the university and the site that this type of training, this type of expectation exists between the university, the supervising veterinarian, and the student's going to be afforded this learning environment. I understand that for the purposes of the university, the accreditation standards cover it. But there's nothing, and I think this is what Dick's point has been, there's nothing in the licensing law that covers the jurisdiction of the board over that practice. This creates an exemption for that practice, that you're going to have a student practicing in a private setting as part of their formal curriculum that are going to be providing service to the public's animals. So in order to qualify for that exemption, there are things that have to exist for that site. And that's what this loophole closes. It's not an attempt to recreate accreditation standards and to essentially say, school, in addition to these accreditation standards that are qualified under the COE, you now have to meet California's standards for education. This covers the setting, the practice setting in California as an exempt site. And I think that's been lost in the discussions with Western and perhaps even a little bit when you and I have discussed this, that it's not so much about accreditation standards. It's more about if you're creating an exempt setting in the state, and there's got to be something that qualifies it as an exempt setting. This is what does it. You could expand A, perhaps, so that it's exempt, and by being exempt, you're saying you meet the accreditation standards and have written agreements. Maybe that's the simplest approach. I think what's freaking everybody out is we have a separate section that says there's these additional things, hurdles that you have to do or you have to jump over in order to essentially make this a qualified educational site. It's really more about how you're qualifying the exemption. And when we approached the committee with this, the explanation we gave them is anytime you're creating the exemption in statute, the exemption has to essentially separate out why a license isn't required, why you don't have a formal prerequisite to someone practicing with the public's animals. Here it's because these are students being taught, and this is important curriculum and important clinical experience that they need in order to graduate and be competent veterinarians. But there should be something that explains where they're exempt and how that exemption exists. And that's what this serves to do. Now, whether or not it's beyond what it needs to be is really a question for the committee. But I think we need to focus back on the fact that this isn't about creating additional accreditation standards. It's about qualifying why this is an exemption.
So, while John's pondering that, my read of 5A is not that that has to be happening within the auspices of the campus. My read of it is that as long as it's part of the formal curriculum, an approved externship by COE, written agreement, et cetera, then 5A is really just speaking to that exemption as long as it's part of the formal curriculum. And then we have other language when it's not part of the formal curriculum, and that's 2027 that we did a ways back. And there are much greater limitations on what students can do in the not formal, the informal, not part of the curriculum. So B was there, when suddenly we create B and we start to talk about off-campus or distributed sites, now that does potentially change what A means. If you just read A as it stands by itself, it means anytime it's part of the formal curriculum, here's the things. You need to be part of this. And again, if they're students of an AVMACOE accredited COE school, then they're meeting the COE guidelines. When we start to then parse out B, the intention, I think, originally was for clarity, and it was for clarity of the supervising veterinarian in this state who may not be aware of COE or the guidelines. And the question ends up being, is it even necessary? Are we fixing a problem that isn't there? Does this help when we open up the Practice Act in terms of one-stop shopping to understand everything that what all of our responsibilities are or not? And does it provide another level of protection?
Dr. Kindler, how does a written agreement protect the consuming public?
It's more the student in that case, so the student is also the consumer.
But again, I circle back to the contents of the written agreement. And you've got some verbiage here that's fine, but then why have it if no one is going to review it?
Well, I think that's where the accreditation comes in.
John?
Yes, Dick.
If there is a problem, a complaint, or just a hospital inspection, and there is a student working there, they can be either working as an employee. If they're junior or senior, they can be working doing RVT skills, or they can be working as an exempt licensee. If they're an exempt licensee, there's got to be a contract. There's got to be something that the board examiner going in can say, if that student is doing more than just RVT tasks, I need a contract with the school that you're working with. I've got to have something to verify that this is an exemption, a license exemption. That's why I see us needing B. When this all started, I was surprised that out-of-state schools were included, because that was the big change from what is present in the existing statute. And because up until this point, we're just dealing with Davis and Western, and as soon as we started including other schools, and I'm talking about unlicensed activity, not RVT activity, I'm saying we got to have something to prove there's a link to the school that's sending that student here. And we have those students come in, and until I have a contract, all they are doing is RVT tasks. They're not diagnosing, they're not treating, they're not doing surgery under direct supervision. It's not allowed. So I think the contract will firm up what they can do, and it'll protect me.
Then it seems to me, pardon me, that you have to have the identification of the student, a description of the status of the student, and a statement about liability in the event of student malfeasance of some sort.
So that would be part of the contract.
Well, then you should say it, because it's not in the statute. And again, we've spent the morning talking about listing items, and here we are in the same conundrum. You start listing things and what's excluded, but I think
But it is stated in that it's an exemption to diagnose, treat, and do surgery in direct supervision, under direct supervision. So
no, I'm talking about the identification of the parties.
Well, okay.
Bill?
I think this is going in circles here a little bit. What's the purpose of the contract?
Is when there is a problem, when there is a complaint, or when there's a board inspection, and that person goes in to do the inspection, there is a link between that student who now has a student license exemption, a link to the school that is authorizing this.
Well, we already have that. You have that with the existence of the exemption allowing the school and their students to go.
So
You just mentioned you're trying to protect yourself. What's the point of, you're not really protecting yourself. The exemption's there, the students can go, the students do, they're within the confines of a pull from above. What protecting you is not what this whole point is.
Well, how can you have an inspection and look at a case if there isn't an understanding, a contract as to the paper trail as to what that student can or can't do?
I think you just go right to the university. I mean, they're in the
We have no
curriculum.
authority over the University of Out-of-State. I'm not having a problem with Western and Davis. This all arose because of allowing students from out of state to come in. I don't have authority over Colorado or Iowa.
Isn't your job as a supervising veterinarian to know, because they're an extern, isn't your job to know what they're doing? Isn't that part
I
of it?
need it in writing. If I don't have it in writing, how can I allow a student to come to me and say, I'm here from Colorado, I want to work this summer, can I do some surgery? Unless I have an agreement with the school that it's part of their curriculum, I have to say no.
Because it doesn't apply to the COE, doesn't apply.
I have no idea what the COE is
But
doing or not doing.
in that
That's all.
situation, you're presumably giving them some sort of credit through the university, whereas if a student shows up from out of state, just wants to work for you, that's a different scenario, correct?
Yes, yeah. So I need paperwork from, and I have it. We just did a program with Massey University in New Zealand. But I was very cautious. I did not have a contract. I had a form, and I didn't feel comfortable letting that student diagnose, treat, and do surgery because I didn't feel comfortable with what contract I had with them. But I think I think we needed to protect the student and to protect the practice and protect the public. I think if there isn't a contract, then all they can do under the existing regulations, in my opinion, is RBT test.
Is it the board's responsibility to protect an out-of-state student studying at an out-of-state university?
Could be a California resident studying elsewhere.
Could be, could not be.
Can I ask a question, Dr. Pasco? If the committee were to agree to expand 5A, because I think it's confusing that we separate out where off-campus or distributed sites provide formal curriculum. If 5A covers any student that's being placed in a practice as part of their formal curriculum, is there a way to expand 5A where we insert language that says essentially the site must provide a written description of the educational objectives expected to be achieved. So that's inserted in A. You do away with B, and then this applies to any formal curriculum setting. It clarifies what the exemption is. So part of the struggle when we went to the legislature is they saw 5A as separate and apart from 5B. And then they looked at 5A and said, okay, well, I think we need to add in where off-campus or distributed sites provide the formal curriculum so that we are essentially describing two different methods of education. If that's not really what the goal is here, if it doesn't matter whether it's a distributed model or it's a traditional track, but you actually can send students out into a practice to get this type of training, that B may not be necessary. It may be A with the addition of there is a written description of the educational objectives that are expected to be achieved at the site. And what you're saying is that there's an agreement between the university and the private setting where that student's achieving or getting their clinical experience. And that may satisfy the need for explaining that there is an exemption, and it's not just they can show up and work there because it's part of their formal curriculum, but there's actually a contract. There's a link between the university out of state and the student that's practicing in California. Do you think that might be an acceptable approach?
Well, it would apply to the two schools in California as well, right?
It would. It would apply to...
And so you're suggesting perhaps after the end of that paragraph, you would add something along the lines of 1 and B. That there must be a written description of the educational objectives expected to be achieved at the site.
Right. Period. And I don't know necessarily that it would just be a sentence at the end. I think that is a little clumsy, but we would have to wordsmith that paragraph.
I think number 3 is also important, providing a mechanism for assessing the training outcomes, because that's the whole purpose of the program is to...
Yeah, I don't want to confuse the discussion. So when it's part of the formal curriculum, that's absolutely true. So we expect it's for us in a way, it's a two-way street. The student evaluates the practice, and the practice evaluates the students, and those come back to the Associate Dean for Academic Program as part of the formal curriculum, right? So it doesn't happen very often, but back when I was actually doing that job, I had a call from a practitioner in the Central Coast area that didn't think that the student was performing adequately, and that student failed that rotation even though it was off-site, so they had to make that up in a different context. Dick sort of muddied the waters for me a little bit because he started to draw distinctions then between a student from anywhere as an employee in the practice versus a student being there getting experiential training.
Well, I see 3 levels. One comes there for summer employment, that's an employee. One that comes there for experience, they're in school, but they're not in a bona fide program. If they're junior or senior, they can do RBT tasks. And then one that comes as part of the program as an externship. So I see it 3 different levels, and as a board, we need to know when we go in there what level that student is doing. And at the top level, that's a student exemption. So I think there's got to be some kind of paperwork, and I'm fine with what you're talking about on A, but there's got to be some kind of paperwork from the university, in-state or out-of-state, that says this is a bona fide program that will allow the student to diagnose, treat, and do surgery in direct supervision.
Right, so back to, just so I'm understanding this, because at the end of the day, the veterinarian's license is on the line, right? So you as the practicing veterinarian or the supervising veterinarian will accept the responsibility for scenario 1 and 2 that you said without any contractual anything with anybody, because that's essentially independent of their formal curriculum or their university training.
Yes.
Right, and C is different because, and so I think I think it comes back to what Diana said, is how robust is this agreement, right? And so at the moment, I'll just describe what we do, is the student would approach your practice and say, gosh, can I come in May for these 2 weeks to do this? And if they get a blessing, then we send something back to you that says, so-and-so has identified your practice. Are you in agreement with that? And so we have to have an agreement back from you. And then I guess the final part of that, so it's not a legal document in how I would think about it, but there's an agreement. It's not like the student just acting as an independent agent. The university is going back. You're saying to us, yes, I agree with that.
Yeah.
And then the next contractual part, if you will, is we say, well, as part of this agreement, you have to evaluate the student and submit this to us. And so there's other bits and pieces, but it's not like a legal document in my sense of the word. It would come back to a written agreement or maybe just an agreement.
Well, the veterinarian is sort of an adjunct professor or something like that. They're assessing the competency of the student, giving a grade.
Right.
I'm still back on protecting the consumer. I'm not convinced that the student needs protection in this scenario. So, Dean Pasco, I'm thinking, the consumer is a person who comes in with an animal expecting treatment at any facility. And for example, and it's too bad Western isn't here, you don't have a written contract with yourself, for example, for your off-site training programs.
Yeah.
Well, we don't have any off-site programs.
Well, you do. We've already talked about that. You have the large animal.
But that is the University of California.
But don't consumers come in there?
Yeah, but it's not off-site.
All right, but okay.
In other words, the difference is that Western University can contract with Dr. Klingborg's practice. That is, by the COE definition, that is off-site. Tulare and San Diego are owned by the University of California. They are not off-site.
All right.
Okay?
But let's talk about protection of the consumer. So, and let's talk about jurisdiction, and let's talk about this section that we're discussing. It doesn't then apply to the University of California, does it?
Not really.
Doesn't at all. So let's understand that. We carve out those consumers that come in there. I don't know about Western because we don't have the representative.
Well,
there.
Western doesn't have an on-campus, or they don't have anything that would constitute a clinical experience. They have contracting all that out.
Right. So let's understand
It actually
that.
does apply. No, I want to stop the conversation before
Okay.
we confuse everybody.
All right.
This does apply.
Yes.
A applies to Davis as much as it does anybody else.
That's true.
It doesn't say we're off-campus sites. Basically, I know.
Not if you follow her line of reasoning.
Right, but
I don't have
that's
to have a
where,
contract with the
that's
student.
where I don't want the train to get derailed. So A applies to everybody. It
Correct.
says if the student is participating in a clinical experience as part of their formal curriculum, they can essentially do surgery under immediate supervision, and they can participate in treatment and diagnosis under direct supervision. And the reason that was added to the statute is because it was unclear whether students, whether they at the VMTH or anywhere else, could actually do surgery and participate in diagnosis and treatment. So let's not confuse, this applies to everybody. There is a second part of this that we're talking about, and that's when the students run off and do something else. So either you make that at a private setting, private facility. So either you make that a separate section, you say, okay, now, separate and apart from what they may be doing in the university, doing surgery at one of the university sites, they can go off and get clinical experience in a practice. If they're going to do that, they need to have a contract. There's a simple way that you can solve this. I don't know if it'll satisfy everybody, but as part of A, what you could say is students of an American Veterinary Medical Association Council on Education accredited veterinary medical program may participate as part of their formal curriculum where the clinical site has been vetted by the program in diagnosis and treatment with, and then so on and so forth. You could do that. So essentially you're combining. If they're going off to a clinical site, that site's been vetted by the university. That takes out written agreement, it takes out mechanism for assessing training, but it does confirm that the site's been vetted through the university. So there's that option. There is, as Tara pointed out, the appropriate language about mechanism for assessing training. That is covered by accreditation. So if the site's been vetted through the university has to comply with the COE. There has to be a written description of the educational objectives expected to be achieved at the site. That's part of the COE. So even with the distributive models, if you look at standard 5, 10, and 11, it also covers educational objectives, anticipated outcomes, thoroughly promulgated and understood by the students and the clinical site coordinators alike. So it's covered.
Okay, so just I'm often accused of writing sentences that are too long. So maybe, just to pick up on your point, maybe sentence 2 could start out something like the clinical training site must be approved by the institution or by the university, whatever you want to do, and the student must have prior training. So that would, what you're trying to suggest is that there has to be some mechanism in place where that training experience is being approved by the institution that student is registered at.
And so if we say university, would that must be approved by the university? Institution is not language that we've used.
No. But I wanted to get the concept first.
Right,
the concept was that the clinical training site was at an approved clinical training site.
Right. Clinical training must be approved by the university, and the student must have prior training in these activities as part of the formal curriculum. And then we'd have to go on and wordsmith the sentence, but.
You might even just do, starting off with students, keep all the first sentence, but then at the end with immediate supervision, if all of the following are met, and little a would be, or I guess big A, the clinical training site is approved by the university and the student has prior training.
Mm-hmm. Mm-hmm.
That way you're really making clear that there are 2 requirements for the students to get this exemption.
And then a new sentence would be that supervision must be by a California licensed veterinarian.
I think that makes sense.
Discussion?
Approved by the university. Again, I could see it working within the state. How would that mechanism work from an out-of-state school?
Well, I think implicit. I guess my assumption following the line of reasoning was that implicit in that is that you would not accept that student. So this is your scenario 3, right? You wouldn't accept that student without whatever satisfies you as an agreement between you and that institution.
Okay.
So we have some proposed language here. Other discussion on that from the committee?
What's our proposed language?
Yeah, sure.
So it would be 5A on page 1 of Dr. Klingborg and Dr. Drusi's report. Starts with students of an American Veterinary Medical Association Council on Education accredited veterinary medical program may participate as part of their formal curriculum in diagnosis and treatment with direct supervision or in surgery with immediate supervision. And it would say something like this, provided the following requirements are met. The clinical training must be approved by the university, which would be A. B, the student must have prior training in these activities as part of the formal curriculum, period. Next sentence, supervision must be by a California licensed veterinarian in good standing, and then the rest of that sentence.
So At the risk of adding more words, just to clarify, the university probably should just say at the university at which that student's enrolled or something
Okay.
for the
Yeah.
veterinary training,
The quality.
something along, something
Okay.
like that.
Bonnie?
Bonnie Lutz, just one small comment. I assume you're going to identify immediate supervision someplace in the regulations because it's not defined.
Maybe.
Excellent point.
Yeah.
It used to be.
I can try. Okay, so it starts with A. We all know the first sentence remains unchanged. There's going to be a period after immediate supervision. And then it'll say, provided the following requirements are met. Let's say for the sake of this discussion, 1, the clinical training must be approved by the university where the student is enrolled. And 2, the student must have prior training in these activities as part of the formal curriculum, period. Supervision must be by a California licensed veterinarian in good standing, as defined in paragraph 1A and B of subdivision B of section 4848.
So move.
Second.
Other discussion? Audience discussion? Call for the vote.
Okay.
I say aye.
Dr. Klingborg.
Aye.
Let me get my page. I don't know who's here anymore. Okay. Dr. Dreesen.
Aye.
Dr. Grant.
Aye.
Diana Woodward-Cagle.
Aye.
David Johnson.
Aye.
Jennifer Laredo. Christy Pulowski.
Aye.
Dr. Pollard.
Aye.
And Dr. Sullivan.
Aye. And I might add, Western isn't here, but this still has to go to the board, so there'll be ample time for them to have some input too.
Right.
Motion carries. Val?
Val Fenstermaker, CVMA. I know you just voted, but we were just wondering, is the term university all encompassing, including like College of Veterinary Medicine?
It's still
Western?
under the university.
So, but how about at Western? The word university covers everything.
Yes.
At every school. You're good with that?
I wouldn't think that there would be,
Just
Western's still a university.
Just that.
Yeah.
Yes, John?
It's a good point, but I think under standard one organization for COE, every school or college of veterinary medicine has to be part of an accredited institution recognized by the government, et cetera, et cetera.
Right.
So that's why universities are overarching. You can't have a standalone
Okay, any other comments from the audience?
One last one.
Yes.
Dick, just because, or excuse me, Dr. Sullivan brought up that the Western would have a chance to come back and meet with the board. As part of the board's agenda tomorrow, we need to consider legislative initiatives for 2018. This is one of the legislative initiatives we need to consider. Because we don't meet again until February, there are several initiatives in there that the board, or issues the board's looked at in the past and said, yes, we need to make this legislative change. This will be one that the board will be talking about. Obviously, there's a long process, so it doesn't preclude Western from coming to the board in February and asking us to consider amendments. It gives me permission to go seek legislative vehicles. I just want to make it clear we will be talking about this tomorrow.
All right, so that concludes the morning session. We will be back around 1:35, 1:40, and back to work. And call the meeting to order. We're continuing with our agenda items. We're on the agenda item that is listed in the board packet is number 5, discussion and consideration of recommendations from the State Humane Association of California and California Veterinary Medical Association regarding public and private shelters and minimum standards and protocols for shelter medicine with potential recommendation to the board. We did have a subcommittee that took this issue. It's been in front of us for over a year now as we tried to work through this complicated issue. And I'd like to hand it over to Dave Johnson, RVT, and Dr. Jeff Pollard.
Thank you, Doctor. And Before I start, thank you to legal counsel for assistance and Anne Marie for staff help on this issue. And welcome to all members of the shelter committee or community. Thank you for coming in today. We always appreciate hearing from you on these issues. What we tried to do with the subcommittee, we've been listening to input, receiving input in writing, as well as hearing oral testimony over many meetings now. And so we tried to deal with the issues that were assigned at the last meeting and try to make sense of some of them, or at least bring information forward to prompt a collegiate discussion on some of the issues. The first issue we took on or reviewed was the veterinary care provided at intake, and the committee is in agreement that from all the testimony we've heard, there isn't always necessarily a veterinarian on staff at every animal shelter or any place where the animals are brought in as stray or impounded animals. But it is pretty much an industry standard that there's certain wellness items that need to take place upon intake to protect the health and the well-being of the animals in the shelter environment. And those involve administration of vaccine for preventable diseases, prophylactic treatment for both internal and external parasites, as well as some diagnostic screening for diseases that could affect the well-being of the other animals in the shelter. And based upon all the information that we've heard and reviewed and speaking with people and recognizing the fact that this is pretty much an industry standard, we do believe that these items should be allowed to be performed on intake, and they should be allowed to be performed by both registered veterinary technicians and veterinary assistants on intake, and that if necessary, we can recommend that we modify 4840B to include the term veterinary assistant, just to clarify the procedures. And so this is probably one of the most important basic hallmarks of shelter medicine is to allow the group of people that are providing the animal health care services in the shelter to perform these tasks on those animals under the supervision of a veterinarian or the guidance of a veterinarian, but not necessarily have that veterinarian physically present when they're performed. And most certainly, though, the veterinarian is involved from a standpoint of writing the written protocols or the procedures to offer the guidance. And so that was the first issue that we came up with the recommendation. The second one was a very interesting discussion that we've heard on and off. There's already been a review by legal counsel on the euthanasia solution, and so we focused strictly on the fact that in many shelters, animals prior to euthanasia are sedated to calm down a frightened animal, to take care of the fractiousness of the animal, or in some instances, the animal's in distress or actually is a dangerous animal that cannot be handled unless it is sedated. There's a group of drugs that are used in combination or by themselves. Several of those drugs are controlled substances, and after reviewing the issue, the recommendation of the committee is that if the pre-sedation or the pre-euthanasia sedation drugs are of controlled substance in nature, then there is going to have to be a veterinary assistance controlled substance permit obtained for the person to handle and administer those drugs. Most certainly that does not apply if the person administering them is a veterinarian or a registered veterinary technician, but it is recommended that in the situation for handling the drugs that are controlled, that the permit is going to be required. Another issue that we were asked to address is one that was brought up about the authority to euthanize wildlife. And we discussed this with legal counsel prior to our last meeting, and I think legal counsel did take a look at current statutes, and we believe that the language that's currently in the Veterinary Practice Act does allow for the euthanasia of wildlife as they are defined as an animal, and that is very specifically addressed in the Veterinary Practice Act. And so there's no action required on this issue. The next issue we took a look at was brought up, I believe, by the State Humane Association, in that there's a problem with getting instructors certified because of where they're training or their eligibility to become an instructor. And we weren't exactly sure the board's role in this because the current language that is in the section is just incorporated by reference by the Veterinary Medical Board. So in other words, they take directly the recommendations from the State Humane Association and their training requirements. So our recommendation is that if there needs to be changes to this section, then language needs to be brought to the board or to the MDC, and the recommendation more than likely would be made that it's just incorporated by reference, and whatever changes necessary to get the instructors that you need, just submit new language. We did not propose any specific language. We feel that needs to come from the profession themselves. The next issue is one that's been debated around and around in terms of the authority the veterinary board has. And at our last meeting, when we were discussing rabies vaccines, we made the recommendation that staff reach out to the public health section, the veterinary public health section, to discuss the rabies vaccination issue. And I'll let Anne-Marie elaborate on that. But again, just to emphasize, yes, public health has total authority over the type of vaccine administered, when it is to be administered, what goes on the certificate, the age the animal is vaccinated, all those criteria, but the veterinary board still controls the circumstances under which the vaccine is given. And so the recommendation, due to the issue of we're dealing with a public health disease, we're dealing with a public's access to services in some areas, we're dealing with the issue that rabies vaccinations are mandated by law and are mandated for licensing agencies to provide those services. The recommendation is that the rabies vaccination be allowed without an examination by a veterinarian for the purpose, if the purpose is to comply with an animal being claimed from a shelter or for the purpose of licensing that animal. And then Anne-Marie, I'll let you elaborate on your discussion with Curtis Fritz.
Yeah. So I did talk to Curtis Fritz, Dr. Fritz from the Department of Public Health, and primarily the goal was to understand the degree of oversight that the Department of Public Health either believes the veterinarian has in administering rabies or would otherwise want the Veterinary Medical Board to enforce. And essentially it goes back to something that Dave put in the document, which is the veterinarian who essentially signature is on the rabies vaccine has to remain responsible for the administration of the drug, the storage of the drug, the handling, and then the management of who, in fact, is administering the rabies vaccination, and make sure those people are adequately trained. But the Department of Public Health has no specific requirements that the veterinarian be on site. So when I asked about signing the rabies certificate, it's not uncommon to have electronic signatures on the rabies certificate or signature stamps by the supervising veterinarian. So that provided some level of flexibility for the Veterinary Medical Board in terms of if we're talking about a shelter setting where prior to an animal being adopted, being able to go home, or just as a matter of a public health intake protocol, a rabies vaccine can be administered in the absence of a veterinarian, so long as the veterinarian that's responsible for the shelter understands that his name is attached, he or she is attached to that rabies certificate, and that he must ensure that the staff has proper training, that the rabies vaccine is being stored in a manner which is consistent with the vaccine, and that if there is something that occurs in terms of an adverse reaction to the rabies vaccination, that veterinarian will be responsible for treating that animal subsequently to that reaction. So that's basically what we learned talking to the Department of Public Health.
Thank you. The next topic that was brought up was indirect supervision and its application to animal shelter sittings. And after review of everything, we've been giving a lot of information. CVMA has proposed some language, and the committee has had different language in the past. So the recommendation was that the new changes to BCP 4840B, where veterinary assistants were added, as well as 2032.1 and the new language proposed by CVMA would eliminate the need for a separate definition of indirect supervision in a shelter environment. So meaning existing definitions of indirect supervision would be adequate enough. The issue in number 7, this was just put together to prompt a discussion. It's not necessarily a specific recommendation, but people keep saying, well, is it an animal shelter? Is it a humane society? What is it? The language of the law is very archaic. It goes back to the 1800s, where it talks about a depository, and hence the name pound came up, and those are both kind of offensive terms to people in the animal sheltering community. And so I just put some references that I found in terms of definitions just to prompt a discussion if it was felt that there needed to be a better definition of what an animal shelter or an animal shelter setting was. And then on number 8, this one keeps recycling itself, and again, it is an issue I think that we need to thoroughly discuss. I know there's been opinions both for and against it, and again, I think we need to continue to look at it. One of the things we've heard repeatedly from the animal shelters is that we can't get a premise permit because we do not have a veterinarian on staff, or we do not have a veterinarian that is willing to be a managing licensee. And when we have met with the shelter community, the large municipal shelters or the large humane societies, this isn't going to affect them. They have a large enough organization that they have veterinarians on staff, they have full-time paid veterinarians, full-time RVTs paid. The concern is that throughout California, there's a lot of smaller shelters that may not have a full-time veterinarian on staff, and their sole source of that veterinary contact might be a local veterinarian in the community that is helping them. And so again, the discussion is, should an RVT be allowed to be a managing licensee for the purpose of a shelter environment? This would require review by legal counsel. It would probably require some statutory adjustment, and most certainly a regulatory adjustment if that was a recommendation that we were willing to make. Also included in the package then is some very specific information that addresses, legal counsel put together, that addresses some of the previous issues that were brought up with regards to veterinary assistance, the fact that in many instances a veterinary client-patient relationship cannot be established in a shelter situation because the owner is unknown, which is already addressed in the law, but in many instances where the animal has been seized for lack of veterinary care or for criminal neglect, you do not want to have contact with the owner. And then there are other situations where the owner has been incarcerated and the shelters have gotten their animals, and there is no way to get in touch with that owner. So there are language there to allow for waiver on the doctor-client-patient relationship. And then I do believe that covers, in general, most of the issues. And I would turn it back to you to start a discussion.
Great, thank you. So comments at this point from the committee? Jeff?
Yes. For item number 2, I think I would like to hear us discuss the idea of using control drugs that, as Dave mentioned, would require a permit for veterinary assistance. And the quandary there is often these would be in facilities there where veterinary supervision might be substandard or not sufficiently, not sufficient in order to literally supervise the use of controlled drugs by veterinary assistants. And if the pre-euthanasia was permitted but did not have controlled drugs, then the people that are in the shelter that know these drugs, Dave listed them, acepromazine, ketamine, xylazine, There are differences of opinion as to their efficacy, their safety, and I also wonder if even the term premix, I don't know literally how it's used day to day. I met Dave in late August at the Department of Animal Services in Carlsbad. And the veterinarian there gave us a great tour and showed us how things worked. And I'm not clear on all the day-to-day, having never worked there, but is premix compounded? I mean, by definition, it's a combination of different items, and so it would have to follow the rules of compounding, and I haven't heard that discussed.
So my thought is we'll kind of take them one by one, but I wanted to see if anybody had any comments kind of at 10,000 feet as you look at it in general. And then we did have a letter that came in from Shaq and wanted to give you a chance if you wanted to talk about it at this point or as we go one by one. Because if we've missed something in this document that we should be considering, then we probably need to know it now as we try and move forward. Did we capture everything? Erica, as I look at what you sent, I feel that most of that was covered in the letter that came from the State Humane Association.
Good afternoon. This is Erica Hughes from the State Humane Association of California. And I think maybe just in the interest of efficiency for this discussion, maybe either kind of amend 8 to say RVTs or shelter directors as licensing managers. Because I think all the other issues are addressed in these in the other recommendations, and some of them we are in agreement with, and others maybe we'd like to see tweaked. But I think the central part of our letter that differs from the rest of these recommendations is the concept of having the shelter director as the licensing manager.
Okay. Great. Thank you.
I'm Eric Anderson. I'm the Animal Services Manager with the County of San Luis Obispo and currently the Vice President of the California Animal Control Directors Association, also a veterinarian licensed in California. And want to speak on behalf of CACTA, and we've also spoken with Shaq about this question. And in general, I think our members and our board support and welcome your board's efforts to bring some reasonable regulation and oversight to medical treatments within shelter communities. Our main concern is that, as was mentioned, we do have a lot of shelters, particularly municipal shelters or public animal services agencies, which are in smaller communities, maybe more remotely located, and may have some difficulty establishing some of the veterinary relationships that are necessary to meet all of these standards. At the same time, those agencies are required to perform some very basic and fundamental animal care functions for the animals in their keeping and in their charge, which have become recognized as essential and key components to a well-managed shelter, protecting the health and welfare of those individual animals, their population as a whole, and the general animal population as well. So some of those things like animal vaccination, administration of parasiticides on intake and things along that line, as well as the sedatives associated with the euthanasia obligation of the shelter. So it's important for us that, for those facilities and our stakeholders that, if possible, we find a way to sort of address the needs of those shelters to be able to continue to perform those obligations that they have in the face of maybe the challenge of having a direct veterinary relationship. So again, some of these considerations as to direct permit issued for the director as well might help to suffice in solving some of those questions.
Okay.
Thank you.
Thank you. Other questions or comments, I should say, or things that we might consider that we've omitted at this stage? We're going to kind of move through these one by one, and I'm sure there will be various folks that will have comments, and we welcome it all as we try and prepare worthwhile recommendation to the board. The other thing, I guess, that I thought I had seen in Shaq's letter, and I think about it, was a specific section in the Practice Act on shelter, and I don't know where we are on that either. If we feel like we need a whole entire section on shelter medicine, or if we can incorporate the language, and when we need to delineate, and in shelters we do X, we do it that way. So that's something else for us to consider as we move through. So issue 1 was the veterinary care on intake, and Dave, thanks for great and very clearly spelling out what you're looking at here, and then the language that is proposed. Do I understand correctly that the language that is offered in your recommendation is also represented here in Tara's document? That
Yes.
you've got the clean copy?
They were blended in.
Okay. Comments, questions on that recommendation for 4840B with the amendment of veterinary assistance? Yes, Jeff.
I feel more comfortable if, in lieu of performing a physical exam, it was referred to as an assessment.
And so I completely agree. I actually did some Googling of physical exam, and it's almost a protected term. I mean, it does imply a medical professional is doing a physical exam. But when I look at the recommendation, it doesn't actually say physical exam anywhere there. So I think we're more comfortable with the notion of it being discussed as an assessment, some of us. But I don't see that the language that's being offered actually uses the word physical exam. So, right, Jeff?
It says perform a physical exam.
Does it? Oh, well, where does it say that in the recommendation? I'm just not seeing it.
The legal counsel.
Oh, I'm sorry.
Yeah, what he's referring to is legal counsel doesn't.
Got it.
They just refer to animal health care services.
Right.
Got it.
Okay.
We took a recommendation and then they blended it into legal language.
So the language that I believe that we would be approving would be the language that is in Dave and Jeff's report.
Or it'd be the language that legal counsel is about.
Okay.
No.
Yes, that is why I'm trying to seek clarification here. So that is.
My report is just explaining the issue.
No, because this says
And to
That
be
is the-
clear,
services on those
the
animals.
proposed language
You gotta look at
that
this.
appears on a red line version
So look at this.
that includes at the very top 4840 of the Business and Professions Code. When you look at this document, I had some suggestions that the subcommittee decided not to go with. So you'll see that in underline and strike through, so that the strike through is not under consideration. So effectively in 4840, the only thing being revised there is to add "and veterinary assistance."
Okay. Are there questions on that from the committee?
I'd like to make a comment. I think that from a public policy standpoint, any expansion of the kind of employees that can give these services in shelters is to be encouraged. And it's not lost on me that because of the fires and other disasters, I have a feeling that shelters are going to be more stressed and less, maybe have to operate with fewer funds even. So if we can expand the kind of the description of people that can give these services, I think it's good public policy.
Ms. Bell?
Is anybody aware of what animal health care services are defined anywhere? It seems very vague.
Is there an understanding
Well,
within the community?
Yes, it is vague. I would agree with you. I was under the impression that some definitions were going to come out of the CVMA's minimum standards for shelter settings that might possibly define some terms. I may be misinformed on that, but we did not address definitions. I thought there was additional work being done, that some recommendations were going to come forth defining some of these terms as well as the setting. Am I wrong on that? Was CVMA working on some minimum standards, or did I misinterpret that?
They had already done it and submitted it.
Val Fenstermaker, CVMA, we had already submitted our work. The premises task force worked on the shelter setting, and we submitted our recommendations last year.
Right.
We moved on to the range setting, but nothing more specific of a shelter setting.
I thought some of it was being modified.
No, what we submitted last year is our
Okay.
complete work
Thank
on
you.
the shelter settings.
Alan?
Well, Hayden has described codified prompt and necessary veterinary care, which unfortunately the governor has suspended as being an SB 90 claim against the state. But I think that the term prompt and necessary care has been ingrained in the sheltering community to mean all these things, whether it be an assessment or a physical exam or vaccinating on impound. So that is out there.
Val, do you have a copy of what we looked at a year ago? It's pretty good language.
It's in there, Dick. It's part of the language that's in, we incorporated it in the language that's in the packet. So if you look at the back side of the page has 2035.5 and 2036.6, which is essentially CVMA's proposal with some wordsmithing.
Okay, that's what I thought.
Yeah.
So it would appear that if we look at the 2035.5 language, and the discussion here is really that animal health care tasks is sort of a vague term. This does seem to try and define those. Limited animal health care tasks may be provided by an RVT in a shelter setting on intake for the specific purpose of controlling infectious and zoonotic disease, controlling acute pain, and maintaining the health and welfare of animals if all of the following conditions are met.
Well, then I would change the term services to tasks, so it at least refers back to that.
So are we looking at the code 4840? Is that where you're seeing services?
Yes.
Okay. So the suggestion would be to revise the code to change services
To tasks.
to tasks.
Right.
That might necessitate more of a broad revision of all of the RVT statutes, which is fine. I'm just making sure everyone's aware that the legislature has used animal health care services, not the board. So to the extent we wanted to change services to tasks, that would be something that they would have to do to go through all of them, all the statutes, and change
But
them.
either that or change task to services. I just make it, because you're defining it on 2035.5, but you're referencing it on 4840. So I think it should be, however we do it, services or tasks. I'm not sure I have one way or another, but it should be similar.
I think you need to conform regulation with statute as opposed to try to change statute. You're going to change the law, then there's going to be a need, you need to have a reason that you're going back and changing the terminology. So if healthcare services is what has been used to define those functions, then your regs should conform with your statute.
Right.
So I would recommend then changing 20, in whatever's 2035.5.
The service.
To say
correct.
To services, yeah.
It seems like we talk about RVT tasks, though, don't we?
These aren't necessarily
Like RVT and
I guess my take on it is that the statutes are more broad, and then the regulations dial down a little bit more and get a little bit more specific. So we're talking about services as the scope of things, the suite, the package of things, and the task starts to enumerate them. And so they are not, to me, inconsistent to use services as a statute and tasks as a regulation.
And tasks is mentioned in 4836, so it specifically says RVT tasks.
Yeah.
The problem is what are animal health care services? I mean, is that surgery? Is it diagnosis? Is it, you know, it's an undefined term, and you're talking about what these individuals can do.
It wouldn't be surgery or diagnosis if it's for RVTs and veterinary assistants. They can't do that.
Okay, well, what about perform a diagnostic test? Or diagnostic testing, because you do have in this...
In limited scope, it's defined in regulation, but I think we're fine.
I don't think this is opening Pandora's box to a whole bunch of things suddenly happening in a shelter setting by those other than DVMs that shouldn't be.
And again, just to remind everybody where we started, it's been the board's policy for years and on their website that it was okay for animal shelters to vaccinate on intake, do parasite control, diagnostic testing, and then as Anne Marie brought the issue forward, you can't have a policy that's not based upon a regulation or statute. So we're just basically catching up and establishing those regulatory guidelines for something that has been the policy for as long as I can remember.
Dr. Anderson?
Yeah, Eric Anderson again. I certainly agree and recognize the need to regulate those procedures that step into the therapeutic and diagnostic range of stuff. I'd like to call attention to, we're talking about what are healthcare services. There are some very fundamental functions which are performed in animal shelters which are really integral to their success in preserving the health of the animals and operating well, which I think are very rudimentary functions and very basic functions that in fact, and again, I don't want to open the can of worms about the ownership question, but these are procedures that are available to the general public to be able to perform a layperson very quickly and very easily with little training, specifically the administration of vaccination, some topical flea medications and things like that. As currently written, to be able to administer vaccination on intake to an animal, a veterinary premises permit would be required, even if that is the only function that shelter is performing. For some of our smaller shelters and shelters that are limited in that as the only medical function that they're performing, I would suggest that may be a large hurdle to establish or a significant requirement to establish simply to perform these very rudimentary functions. And that there may be some of these very basic and skilled and pretty easy functions that we were expecting shelters to be performing that might actually be carved out of this discussion, and there may actually be, I would actually even suggest possibly for consideration, a premises permit for shelters in a very limited sense to shelter directors to allow for some of these very basic functions that they're mandated to perform, the administration of vaccinations, parasite control, euthanasia services, including pre-sedation, and that it be restricted to simply those directed animal management and welfare issues that are imperative and not stepping into that therapeutic diagnostic area. Certainly once diagnoses, and even I would go as far as the leukemia test or ringworm screening being a diagnostic procedure, that falls into a veterinary premises function. But I think that for some of the smaller shelters, that question of being able to just administer basic vaccination on intake without having a veterinary premises permit while still having reasonable regulations on the agency would be an important consideration.
It might be helpful if I could go over item 6 right now, since it seems like the overarching question is whether or not a shelter can operate without a licensee manager. So quickly, I think we're all under the same impression that the statutes provide that only a California licensed veterinarian can be a licensee manager. Presumably this is because The veterinarian has more training, more education. So what we're really talking about is whether or not an RVT could manage a veterinarian, because most of the Practice Act and regulations require supervision over RVTs and VAs. But if we have a licensee manager who is responsible for making certain that the facility, and we all know that we're talking about a premises permit, that's why you need a licensee manager. But who is the RVT going to be managing and making sure that everyone who works at that facility is complying with the law? So really, we're looking at an RVT managing and making certain that there's no unlicensed practice going on at the facility. So you've got a manager who's an RVT over a vet, which is that good public policy? Does an RVT know when a vet is performing unlicensed practice or not reaching the appropriate standard of care? Because that's what the licensee manager does. They make sure everyone is practicing appropriately. They're also making sure the facility comports with regulatory requirements. So in what situation should an RVT be able to practice animal health care services without a veterinarian being responsible? So I took a look at a similar situation. I think, Diane, you had brought it up at the last meeting, which was dental hygienists. Right, so it's an analogous situation where typically dentists manage or supervise the practice of dental hygienists within their facility. However, the legislature has authorized solo practice, or something called dental hygienist alternative practice. So there are some activities that a dental hygienist can perform unsupervised. Otherwise, it requires either direct or general supervision by the dentist. And in the dental world, general supervision is like our indirect supervision. So what are the tasks that they can do? Let me look them up here. They are not administering vaccinations, I can tell you that, or anesthesia. It's really limited to. One-stop shop. There we go. Oral health education, counseling, health screenings. Because none of that really involves diagnosis, treatment, pain management, and if there's anything serious that's found on a patient, they are then required to refer the patient to a dentist. So when we're in the animal context, I'm posing to everyone here, what animal health care services or tasks would be appropriate for an RVT to authorize, perform, or have someone else, like a VA, perform without supervision?
Bill and then Dave.
Dr. Drusi used a term evidently that is understood in the community, and it would seem this is really what we're talking about, was prompt and necessary care. And I think that would fit better than animal health care services. That doesn't tell me it's an emergent situation. It doesn't tell me that they can't do diagnostic testing. You know, there's a lot of different things that I think are wide open to that. But registered veterinary technicians and veterinary assistants may perform prompt and necessary care on those animals, and then this goes on. I think would be a better way of looking at that.
Well, at what point is an RVT crossing over into the practice of veterinary medicine? That's really the overarching question.
Well, I think this is the whole reason we had this discussion was there's just not a veterinarian available in some of these instances. And we're trying to help the shelters that don't have veterinarians there, and that they're standing orders and, you know, things that have been set up, and so it would allow prompt necessary care.
Which I think the new 2035.5 and .6 would establish. It would authorize the RVT and VAs to perform certain healthcare tasks on intake.
And if you go back to that 2035.5, they talk about that, pretty much that, controlling acute pain, zoonotic disease. I mean, this is prompt necessary care.
Dave and then Dick.
Well, again, this just gets back to that basic discussion that started this all, was for years, the frequently asked questions on the board side said, if you're only administering vaccines on intake, if you're doing parasite control, and if you're internal and external parasites, you do not need a premise permit, because it's not the practice of veterinary medicine. And so that's what the small shelters are asking for. Those that can't get a full-time veterinarian, those that don't have a veterinarian as a managing licensee, they want to do the basic wellness on intake without a premise permit. I'm okay with that, but the second it starts to get into pain management, treatment, diagnostic testing, then they should have a veterinarian and they should have a premise permit. So I think we're looking at this issue. There's yes, we have language that says the veterinary assistant or the RVT can do these things on intake, but it's tied to the fact of, do they have a premise permit or not? And a lot of these smaller shelters, and I see you nodding your head in the back, in agreement, I hope, is that they can't get a managing licensee for a premise permit, but all they want to do, they have some kind of a working relationship with the veterinarian in town or somewhere, and they're vaccinating the animals on intake, they're doing oral worming medications, and they're doing flea treatments. And that's the level they want to be able to do to keep their shelter healthy. And I think we need to address that issue as part of shelter medicine, and then take the step further and say, once you go beyond that, yes, you have a premise permit. And then you can have your discussion of, should the premise permit be with an RVT or a veterinarian? We'll just figure that one out. But I think we don't lose sight of the fact that that smaller shelter needs to be able to do those wellness items on intake without the premise permit, because they're going to have trouble getting that premise permit.
Well, what about the situation where we've got a veterinarian who is the licensee manager, because I don't believe there's any requirement in the statute for the licensee manager to be a full-time employee of the premises, because you actually have licensee managers being named on multiple premises.
Right.
So what's the real problem? I mean, if we're authorizing them by regulation, as we're talking here today, to perform tasks, certain tasks, emergency tasks on intake under indirect supervision pursuant to orders, the licensee manager most likely has set up those orders. Because otherwise, who sets up the written orders? Who's doing that?
Dick.
Is the RVT manager? So when there doesn't appear to be any requirement for daily direct supervision or daily licensee manager inspection. So is it possible to get one veterinarian to service and serve as the licensee manager for multiple locations?
Dick.
Yeah, I'm kind of looking at this a little different approach. I think this is another example where we can use the herd health approach, and or probably the perfect example is a dairy practice where the veterinarian sets up the protocol out on the dairy, and when there's a cow that is sick, he doesn't go out there in that individual case. He has set up a protocol to treat that cow with those symptoms. He does timely visits. It's part of the VCPR. And I don't see where we can't take that scenario of the VCPR and apply it to a shelter practice where, very specifically, a veterinarian who may be 30, 40, 50 miles away has the licensing managing duties of that shelter, sets up the protocol, has oversight of what's going on in that shelter, but is not there every day, doesn't need to be there every day, no different than that dairy practitioner. So I'm very concerned anytime we start compromising the definition of licensing manager, because I think we're going to get a whole group of other special interest groups coming in to chip away at that too. I think that we have a model there that we can use in these remote shelters, and I think that, and I agree, a veterinarian may have several licensing managers' responsibilities, and I think it can work without compromising and changing what is a real critical part of our Practice Act, and that's the licensing manager.
Eric?
Yeah, again, I don't think we clearly recognize the boundary between anything therapeutic and diagnostic, prescription or calling out on a disease or anything along that line. And that really is the realm for veterinarians in that practice. Going back to these very basic vaccination, parasite control functions, it is possible for a veterinarian to have a sort of a passing relationship with multiple shelters over an area. But some of the shelters that we deal with are very small communities, remotely located, so they may have difficulty identifying anybody nearby who's willing to take that responsibility on and to engage in that process. Additionally, a number of the smaller shelters, particularly smaller municipal shelters, are struggling very significantly right now with budgetary and fiscal status. And I do have a concern that actually contracting out for an additional service simply to provide vaccinations to animals on intake, when you're looking at some of the administrative boards that are making decisions on budget and administration and so forth, may look at that contract as an excess cost that they're not able to bear at that point. And if they don't engage in that contract as far as a municipal administrative level, that then would preclude the shelter from being able to go down to the local ag supply store and just pick up the vaccinations there that would otherwise be available to those same animal owners to administer if the animal weren't in the shelter and so forth. So I think the question is really a very small subset of functions which are integral to providing and ensuring the health of the animals there in the shelter and preventing the rapid spread of disease in these areas. So again, I'm really kind of suggesting maybe carving out, looking at potentially a shelter premises permit, which is very defined, very limited. If a premises permit is really required, that potentially could be issued to a director, or if they have a veterinarian or a RVT on staff. But really, I think it's just a very limited set of these functions, which, as you mentioned, have been sort of acknowledged as not requiring a premises permit up until this point. So it seems like we're actually stepping into, because of the way the regulations are set up, really extending regulations onto a group of shelters and operations which haven't, although technically regulated, have never actually been effectively regulated, never effectively been subject to this, and have been trying to do a good job and really hasn't created a problem in that respect. So I'm really kind of encouraged looking at regulating shelters based on their function in performing therapeutics and diagnostics, and that should be the threshold for where we do a premises permit.
I have a question, and it's one we've struggled with. When we've been at the meetings and we ask for a show of hands who has premise permits, most of the people raise their hand, but these are the large shelters. Do we have any clue throughout California how many animal shelters or facilities don't have premise permits but are offering, are fulfilling the law of prompt and necessary veterinary care?
It would just be anecdotal if I were to tell you, but my impression is that many would not want to identify, once they become aware of that, would identify themselves. Sure. And to be honest, I think there are really a very, very large number of shelters that particularly if they're not engaging in actual veterinary functions of diagnostics and therapeutics, if they're not doing that and they're just doing these vaccines on intakes and euthanizing animals, I think there's a very large number of them which probably do not have premises permits at this point. But that's really just a subjective,
I would say that if they're euthanizing animals, they've got access to controlled substances, and that's if they're administering without any supervision of any veterinarian,
Well, then
that's,
you
I mean,
have
how-
animal control officers or humane officers doing it.
RVTs can
Yeah,
obtain sodium pentobarbital for injection.
okay.
and so can humane officers. Those are the people that work as active, the animal control
Okay.
officers.
And again, I would distinguish between their relationship with the DEA license holder and access to the controls versus the actual premises permit for operation of a clinical facility.
Okay.
But I don't, oops, sorry.
So we've got people who want to talk, Alan, Anne Marie, Nancy.
I think there are a number of things here that need to be clarified or understood or brought to the front. I do not disagree that the problem for some rural areas may be an access issue with a veterinary professional, a veterinarian that would agree to have carry the premise permit. But I would hazard to guess the main issue with that is that either there's not a veterinarian who wants to assume the liability associated with the premise permit, or the organization does not or have the money or doesn't even want to fund a veterinarian to obtain a premise permit. I know a couple of places that a veterinarian in name only, he carries the premise permit, he gets $1,000 a month from the organization, and he never goes there. So there are those situations out there. Another question in my mind is I know that the jurisdictions that have animal control contracts with organizations, the animals that we receive never belong to us. We are a depository for those animals. As a manager of these situations, I would never want to obtain ownership for liability reasons after an animal is then adopted or transferred to somebody else. I don't want to be liable for that. So the question in my mind arises, these small organizations who may not even have contracts with municipalities, who owns those animals? Are they on a different scale where they are no longer a depository after the whole period, now it's 72 hours? In contrast to a municipal animal shelter, do those organizations own the animals then? If they do own them, then maybe they can skip the exam for 72 hours, and then the question of their owner, anybody can do anything they want with it. Would be my point. Certainly, if they take owner surrender animals, immediate upon signing of the contract of the owner surrender, do these organizations own these animals? We still don't. We as a animal control jurisdiction, we still don't. We still consider them a repository. So, I don't want to complicate things, but the not lawyer in my mind would want answers to these questions if we're going to decide at what level of oversight the Veterinary Medical Board wants to have with these types of, varying types of organizations.
A couple things that I think we need to call out here. In suggesting that the board regulate a shelter director who is an unlicensed individual, the board has no authority over unlicensed people. So to name someone outside the practice of veterinary medicine that we're suddenly going to regulate who's just a layperson would not fall within the scheme of oversight. The board's mandate and mission is to regulate veterinary medicine and those that practice veterinary medicine. So I think it would be a far stretch for the board to name an average unlicensed individual who's not necessarily practicing veterinary medicine, doesn't have any direct supervision, doesn't have any training, doesn't have a defined scope of practice. So that's my first comment. Secondly, we talked about RVTs as licensing managers. Probably the most significant hurdle is, I think Tara was pointing out, that an RVT isn't an independent practitioner. An RVT only functions under some level of supervision. So now you're placing a person who's not defined by the statute as an independent practitioner in a position to supervise others when they themselves don't have the authority to practice independently. So there's a structural problem there as well. From the standpoint of whether or not a shelter is practicing veterinary medicine, Dr. Dave Johnson brought up, I do this to you all the time, he's honorary doctor. So I can't do that either in real life. But Dave has brought up on a number of occasions the FAQs that used to be on the board's website. And those essentially said that under some sort of written protocol or written order, that shelters may do certain intake provisions for animals. It didn't say those shelters were exempt from a premises permit or we're not practicing veterinary medicine. So I don't want the FAQs to be excused with there was a blanket exemption out there for many, many years that said those shelters weren't practicing veterinary medicine. What it said was there were certain intake functions that could occur without the presence of a veterinarian under written protocols. And those are the same exact services that you've been discussing today. These are prompt, if you want to call them prompt and necessary care provisions, but they're intake services that the shelter has a responsibility for the health of the animals in the shelter, but also for the public's general health to provide those services on intake. That's separate and apart from who should be responsible for the premises. I understand the logistics problem that we're dealing with, or financial problem, which is how do we get someone to contract with these smaller shelters so that they have those written protocols, so they have some veterinary involvement. If you wanted to completely carve out these intake services in shelter medicine from being exempt from a premises permit, you would have to exclude those services for the purposes of sheltering animals. You'd have to exclude them from the definition of veterinary medicine. And I think that's where there's a great deal of trepidation on the part of, the veterinary profession, and even from a consumer protection standpoint, this board, to say those things for this setting are no longer defined as veterinary medicine. Because what's the next exempt setting going to be? Where's the next? Is it going to be rodeos? Is it going to be dog shows? I mean, we've heard shelter medicine is one aspect of perhaps a unique setting where veterinary involvement is limited. But there's many other settings that use the same argument or justification for saying we shouldn't have to follow the rules of a traditional veterinary hospital. One of the reasons why we went down the road of creating alternate premises types was to address some of these unique settings where you're not doing surgery, you're not doing diagnostics, you're not doing, let's just say, more complex intervention. And by doing that, you're maintaining that you're still practicing veterinary medicine. However, the level of oversight to which that certain medicine may be practiced in this setting can be scaled back because of the population that you're dealing with. My main point here is removing the licensing manager from the equation is problematic for a number of reasons. One, an RVT isn't an independent practitioner by definition. A layperson, the board has absolutely no oversight over someone who is not licensed, trained, or supervised to practice veterinary medicine. So I don't know how you would legislate for that, Erica. I mean, that would be something that would be highly unusual.
This is Erica with State Humane. I guess, looking at 4820 Business and Professions Code, Section 4827, we do have a precedent for a carve-out for animal shelters for the administration of sodium pentobarbital by non-RVTs and non-veterinarians in a sheltered setting who have been trained per Section 2039. So, and sodium pentobarbital is a controlled substance, and it's we're talking about euthanizing an animal, which requires a fair amount of training and skill to do humanely, and so backing down from that, what we're talking about, perhaps if we were talking about the exemption route, is exempting healthcare tasks that require less skill and have less potential for harm than the administration of sodium pentobarbital.
But that wouldn't be the same as the board regulating an unlicensed individual not practicing veterinary medicine.
And I agree. I was only responding to you presented you discussed the option of having a non-veterinarian as the licensing manager. And then you also talked about a situation in which perhaps we would do talk about doing a carve-out that would exempt certain healthcare tasks from the practice of veterinary medicine. And so I'm speaking to that if we went down that road, doing the carve-out, that there is and to your point that everybody wants to. There are many other settings that that ask for carve-outs, and I just wanted to make the point that there's a precedent for doing that in the shelter setting. The legislature and the VMB have already recognized that shelters are different than regular hospitals and also deserve a special consideration that perhaps other settings that are different than regular hospitals don't deserve.
We've gotten bogged down here, it seems, on issue 1, veterinary care on intake, because suddenly there's concern that some of the more basic shelter functions, performing an assessment, administering vaccines, and parasite control, by putting that into 4840B, we are now excluding certain kinds of shelters that just provide those services and not anything that involves pain control and things of that sort. We've eliminated a whole class of shelters from being able to do that. I guess when I look at 4840B, by definition, I feel like if we put some language forward, that is pertaining to shelters that have premise permits. It's not necessarily pertaining to those that don't, anymore that we don't regulate dog grooming salons and things like that. So what I'm wondering is if in 4840B, we simply need to identify what type of shelter needs to have a premise permit. And it's not just that they provide a physical assessment, vaccines, and worming medication, but they do these other things. And we define that group that needs a premise permit as providing this level of service. And it does enumerate the basic services as well, just for sake of clarity. But that is not necessarily excluding some other group that doesn't reach that higher level of service from doing their thing. Does this make sense?
It does make sense, and I can say that the CACTA and CHEC boards met recently and discussed this at length, and the initial thought was not requiring a premises permit, but kind of carving out these certain tasks that can be done. But then when we got to the subject of pre-euthanasia sedatives, we didn't think it was reasonable to ask for shelter staff to have access to controlled substances and have the ability to administer it without any oversight. We didn't think that was going to fly in any world. While I think that the idea of carving out these certain tasks, vaccines and deworming medicine, makes sense, it doesn't solve the issue of pre-euthanasia sedatives. Because the boards didn't think that would be an appropriate task to carve out and be unregulated. So that's kind of, and so that's how we got to we agree that there needs to be regulation. We agree that VMB oversight would be good, but we are concerned about the availability and the willingness of veterinarians to serve as the licensing manager, and that's how the idea of the shelter director came to be.
So is the bottleneck here to getting a premise permit, having a veterinarian to function as a licensing manager? Is that the hardest part of what you need in order to have a premise permit?
Yes.
Yeah, I think that's really the key, and really for these very limited sets of functions, that is where that's a question.
Alan.
So one of the reasons, besides the horse industry circling the drain in the late 90s, one of the reasons why I got into shelter medicine and public health was to raise the standards of care in the animal shelters. Colleagues to my right know what some of the shelters were like in the 90s. I mean, and certainly in the 80s and 70s, they were even worse. And over the years, it's been my feeling that the only way to continue to raise the standard of care in every type of animal shelter is, since there is some semblance of veterinary medicine being practiced in all these shelters, that the only way to continue to raise the level is to have veterinary medical board oversight of what occurs on these premises. And although we may find it very difficult today, certainly, to agree upon a modality to affect that change, that remains paramount in my mind as to what we should be doing for the protection of the animals and their owners, and the community at large.
So our discussion here on item 1, again, has been kind of derailed because suddenly we've got this parallel discussion about a shelter 1 and a shelter 2, which meet different kinds of criteria. I don't think we're going to solve that right now. I actually want to try and continue to move on and look at this document a little bit more and see if we can move forward with this discussion at this point. I wish, quite frankly, this part of the conversation had come forward to us some time ago in a way that I grasped rather than now. But we clearly need to grapple with the definition of what is a shelter and what then needs to have a premise permit. I mean, obviously that needs to be an integral part of the discussion aside from some of these standards and protocols. I think we should make an assumption that these standards and protocols are for those shelters that have premise permits, continue our conversation, and then try and figure out the other part of this along the way, because we're not going to get this done tonight, clearly. Okay? So anything else at this stage? Yes, Dave.
I think it would be appropriate at this point, since we are on item 1, to move that we add the recommendation of the committee and that we see on in the model 4840, at the write-up of it, of adding the words "and veterinary assistance" to 4840B.
Now that was the only housekeeping change on that, right? Okay, there were additions and then they were deleted again.
No,
right.
no. I think the way we had 4840B, as I understand it, is it would read registered veterinary technicians and veterinary assistants, which is already there underlined, may perform prompt and necessary care on those animals impounded by. Is that correct?
That's what yes.
Yeah.
Yes.
I will change the motion to move that.
I'm concerned about that language being too limiting, because if we add prompt and necessary care, that means that RVTs and VAs can only perform prompt and necessary care on animals impounded.
And that's further defined in the next section adequately, I believe.
Well, what about shelter situations where you're maintaining the animal for a couple of days? That's no longer necessarily prompt and necessary care.
The idea with the CVMA committee that looked at this was, at that point, a veterinarian has to get involved. If it's a medical condition.
But what about when the veterinarian leaves the shelter? Who's taking care of the animals at that point? Because if we change may perform animal health care services to something more limiting, to only allow them to provide prompt and necessary care, we're I think, unnecessarily making the statute too small, too limiting.
I think necessary care is unlimited time.
Yeah, why would you provide care that's unnecessary?
But how do you define what's necessary? I mean, is worming every animal that comes in necessary?
If you're in an animal shelter, herd health, and the answer is heck yes.
Well, no, you're making an assumption. I mean, maybe that you don't know. Have you done a fecal exam? It may not be necessary.
Herd health.
But we're forgetting
now
the
it's a
rest.
different standard.
Sorry. We're forgetting the rest of that sentence that is qualified by pursuant to direct written and telephonic orders. So we're still looking at this as protocols. So that prompt and necessary care is going to be defined under those protocols, just like intake procedures are currently defined under protocols. So we're changing prompt and necessary care, I think, to be more cohesive, if you will, or in concert with the civil code, right?
Exactly.
Okay.
With
So-
the civil code?
This is enabling legislation. Then we go to
Exactly,
regulation.
exactly. This is just saying, hey, you can provide care. Then the board figures out what that care looks like. And I think the board, in figuring out what the care looks like, would add prompt and necessary in certain circumstances as necessary. But I think when we change the statute, which authorizes them to just do care, any care, on impound animals pursuant to orders, I think that's sufficient, and then the board figures out what that means.
David and then Leah.
I'm just making it real simple, getting back to where we were trying to start with this. It was just brought to our attention that we have animal shelters that don't have registered veterinary technicians. They wanted veterinary assistants added into this. That's all we tried to do, was just add, since it's a statutory change, we tried to make it incredibly simple and just add veterinary assistant into it. And then, yes, you can expand that out with all kinds of definitions once that statutory authority is there in the regulations. But to try to add more to the statutory part of it, it might be a real slippery slope. And so we just added that in there because the way it's currently written, it's only the RVTs that can do the telephonic, written, or whatever orders. Many shelters only have a veterinary assistant. That's why it was added in there.
Leah.
All I was going to say was this issue number 1 recommendation also referenced 2035 or 0.5 and 2036.6. And in 2036.6, it does say supervising veterinarian may establish written orders of the performance on intake of a physical examination. And I know Dr. Pollard and some others had mentioned changing that to assessment. So I just wanted to point that out before it was moved forward.
So, Bill, you brought up prompt and necessary care, and yet now we're not internally consistent with their document because it reads differently in between the statute and the regulation. And I guess I'm still confused why that adds anything that animal health care services was not acceptable.
Because it goes back to 2035.5. And it's just inconsistent. There's nothing, when I read this here, and it's not just, again, what this group is, it's everybody down the line, years from now, that's going to look at this. And may provide animal health care services. In my feeling, you either define that term, so everybody knows what that is, or you make it understood what we're really talking about. And what we have talked about since the inception of this discussion is intake. And you don't have time in these animal shelters to put it away. You know, you're concerned with herd health. And so prompt and necessary care, it wasn't my term, actually Alan came up with it. And I think it's it really defines what we're talking about. And that's why there's one or two pathways to do it.
Leslie.
Thank you, Leslie from CARFTA. And this just goes back to what Leah just stated, is, you know, we just want to be on record with CARFTA that we do not believe that veterinary assistants can safely and with any training perform a physical examination. And so that we would like to see that verbiage removed. We don't particularly have any issue with them performing, you know, immunizations or a deworming protocol that's been established by a veterinarian on intake, but the function of a physical exam should be limited to a DVM or an RVT.
David.
I would recommend that, since this issue is talked in circles, and if there is a concern that we define prompt and necessary, then 2034 is our catch-all category of all the animal health care task definitions. Mm-hmm. So then we just need to make a recommendation that we drop a definition in there and keep it out of the statutes, drop it in the regulation with all of our other defined terms. because it covers everything, registered veterinary technician, permit holders, and veterinary assistants. Here's the terms.
For the sake of completeness, Haydenville modified the Civil Code 1834, which states a depository of living animals shall provide the animals with necessary and prompt veterinary care, nutrition, and shelter, and treat them kindly.
I knew I got that somewhere.
So do we have a recommendation for language for 4840B? Bill?
I don't think we got a second, did you second it?
I did, well, it wasn't an official motion, but I would make the motion
He made the motion.
of prompt and necessary care.
No, and veterinary assistance, and you wanted to add, and I said
Right.
it was acceptable.
So then as a friendly amendment to Dr. Sullivan, you just need a second to that, or whoever made the second. Was it seconded?
I don't know.
No, we're still waiting for the motion.
To move that 4840B as amended and veterinary assistance be added, and strike the term animal health care services and replace that with prompt and necessary care. So the sentence reads, may perform prompt and necessary care on those animals impounded, and through the rest of it. That's the motion.
Who made it?
I just did it.
Oh, Dick, your motion's gone.
I didn't.
There wasn't a second, so we just remade it.
Seconded.
So you've seconded the motion.
I'll second it.
Are we troubled at all by the fact that Hayden refers to it as necessary and prompt care, and now we have called it prompt and necessary?
And it also says veterinary care.
You can make it consistent.
Necessary and prompt care.
Perfect.
Necessary and prompt veterinary care.
Necessary and prompt veterinary care. So it's consistent.
So we have a motion and a second. Dick?
Somewhere along the line, I think Dave brought up, maybe at the last meeting, the question of whether this then includes private shelters.
Later on.
It does.
So I think the comment, the comment that was made at the last meeting was that, and perhaps now that we have Katha and Shaq here, we can ask the question, majority of shelters have contracts with these other public entities or municipalities. Are there a number of private shelters that aren't contracting with a city, county, or public entity? Okay. Then they would not be included.
Bonnie?
Okay, Bonnie Lutz. Yeah, first of all, just to answer that, there are a number of those shelters that are not contracting, but I think what I would suggest, since you're going to mess with the statute, which I agree with, messing with the statute is sometimes not a good idea, but since you're already talking about revising it, that you add similar language to what you've got in 2036.6 that says includes the SPCAs and Humane Societies, which contract with the cities and counties, because there are a number of SPCAs and Humane Societies in California that do not contract and don't do animal control. And I think we have to be really careful that we're only looking at animal control agencies and not rescues, because that gets us into a whole other ballgame of difficulty. So what we're talking about here, I thought, was, we're talking about government, which is city, county, municipality, shelters, animal control shelters, or SPCAs and Humane Societies that contract with those cities or counties to perform those animal care and sheltering services.
Can I ask Bonnie a question? Then what about like a city that contracts with a private entity? Is that, even though the entity itself is a private functioning unit, is that, so is that public or private?
Well, then that, you've added the language in 2036.6. So, I mean, it should be added here, because yes, they're performing the same function. So that private, whether they call themselves an SPCA or a humane society, they're performing the same function as the city or county would perform, only they're private. I mean, they're private nonprofits, but they're still held to the same Hayden standard and Hayden regulations and everything else that the city and county standards are. I mean, they do animal control and animal sheltering.
I thought we looked at the statute earlier and said as long as they're contracting with a city, county, basically a public shelter, that you didn't have to call them out specifically because they still fall under that public agency.
Yeah, and I agree with that, but I'm just questioning, since you're already changing language in the statute to make it really clear, because you have added that language in the regulation 2036.6 to specify that
Because the
it also
regulation,
includes.
right. And the regulation was intended to make that statute more specific. So I don't know that you need to add it to both places. I mean, I think from the standpoint of, we as a government agency contract with a lot of different entities to do work, it's still governed by the state agency, even though we're contracting with a private vendor. I don't see this as any different. And then the regulation further specifies that. I guess my concern is if what we were talking about here is if what was brought forward today is we have a problem with the private shelters that can't meet these standards, and they need an exemption in order to do intake services, right? These.
I don't. Could you respond? I don't think we're talking. I mean, I think we're talking apples and oranges here. And correct me if you think I'm wrong, but we're not talking about private, the agencies that they're talking about that can't get vets as premises, as licensees managers are not necessarily private. They could be government, they could be cities, they could be.
But that wasn't the statement that you made earlier when we said how many shelters are out there that don't have premises permits and don't have a managing licensee, and we asked about private shelters. My understanding was that was one and the same. I think we all need to be clear about.
I'm sorry if I misunderstood, and you know, I would speak on behalf of public and municipal shelters and animal control agencies, and I would leave Derek to talk about private, nonprofit humane societies. This is an issue for public, municipal, and county government-run, or in some cases private agencies which are contracted to perform government-mandated services for the public. There certainly are, I'm sure, issues related to private nonprofit organizations as well. Erica could speak to more, but that's a little outside of my expertise.
And the issue exists with public shelters as well as private shelters that contract with public shelters or public agencies, and private agencies, shelters that don't contract. But yes, I mean, I think our primary concern has been with the public agencies and then the private shelters that are contracting with public agencies. Sitting here, I can't tell you the extent of the problem with private shelters, just that in terms of our discussions, we have been prioritizing the issues with public shelters because they're required to take in the animals, whereas private shelters aren't necessarily, unless they're doing it under a contract, aren't required to take them in. But I don't want to exclude them from the conversation. So maybe it's not helpful to prioritize at this point. So yes, we're talking about all of them.
Yeah, as I read this, we are excluding private shelters, and I think they need to be included.
So how do we define them?
There's a definition of animal shelter entity in the Civil Code. This is about one of the few actual definitions for shelter. So it says 1834.7A2, animal shelter entity includes but is not limited to an animal regulation agency, humane society, society for the prevention of cruelty to animals, or other private or public animal shelter.
So it sounds like we need to make a reference to that as we think about this.
Yeah, my only comment is just that I think we need to really be careful that we don't get into the realm of rescues and other private organizations, because then that gets into the owned animal exception and all of that depository stuff. So.
You do have a yes, sorry, Nancy.
I'm concerned about the prompt and necessary addition it's, the way it's currently written, this allows an RVT or now a veterinary assistant to perform, in my interpretation, those animal health care tasks that are already legal under the Practice Act, as long as there's a veterinarian who is providing a direct written or telephonic order. If you say prompt and necessary, is that it has to be both prompt and necessary? You are opening up people for all kinds of lawsuits because somebody decides that you did this procedure an hour later and you should have done it a half an hour ago. That wasn't necessary. Those are the decisions that should be made by the staff, not by somebody else. And what does prompt and necessary mean? It doesn't mean anything in this context. We already have a list of job tasks that RVTs may perform and that veterinary assistants may perform. And this doesn't allow them to do anything in addition to those things, except in terms of supervision. So I would strongly recommend that you do not adopt the prompt and necessary language. I think that it adds a whole lot of complication without any additional benefit. And because Jerry Brown said it in some kind of statement, that doesn't make it good law language.
Nancy.
He wasn't trying to write a law, he was just trying to make a statement.
Hayden's been on the book since '99.
Yeah. Yeah, but
there was no problems with it at all. There was some backlash about how much it would cost the jurisdictions, but that was allegedly solved by SB 19, right? That big pot of gold in Sacramento somewhere. It has been suspended by Governor Brown only because he doesn't want to provide that revenue stream back to the cities and counties who perform these services.
I don't see how necessary and prompt care gives any more direction or less direction than animal health care tasks gives. I mean, I think that animal health care services and or tasks already lives in the Practice Act, and to me this doesn't add anything new. And there is a potential for misinterpretation. That badly matted animal, but you didn't have the staff to sedate it in order to address it. It needed prompt and necessary care, but the issue was a staffing issue that day. You know, I don't know who the liability goes to on something like that. It's an unknown animal, but it seems like that's a directive that has no teeth and provides no insight to me. Other comments?
Grant Miller, CVMA. Just one comment that if the committee chooses to include veterinary assistance as an amendment to 4840B, there may be a need to, for the purposes of that section, define veterinary assistant, because in regulations, veterinary assistant is really, they're mentioned in 2036.5 as providing auxiliary healthcare tasks. Well, by the nature of its definition, auxiliary means they are providing assistance to who? A veterinarian. In this context, there is no veterinarian. So what is a veterinary assistant? It could say registered veterinary technicians or anybody may perform prompt and necessary, because we don't know what a veterinary assistant means in this context. So it might be something to consider as you move forward.
So Grant, is not the fact that they're providing the animal health care services pursuant to the direct written or telephonic order of a veterinarian, does that not link the two?
Well, isn't that RVTs though? I mean, that's so.
But we're adding veterinary assistants to
well,
that.
But what is a veterinary assistant? I mean, why are you saying the word veterinary assistant? No, the statute has no definition of what that is. It just means anybody.
Yes, it does.
It just means a person.
It's already included in subdivision A
It's in 2030.
of the same section.
So we may need to further define what that is. What is a veterinary assistant? Because, okay, we know what they're doing, registered and registered technicians, we know what they are. They have a license with the state. They're approved to perform those services, but approved by who? Who are they? Thank you.
I was just going to comment that it is defined. 2034C.
What?
2034C, it is defined. It's anybody who isn't a veterinarian or an RVT.
Right, but in an animal healthcare setting where they're working under the supervision of a veterinarian, for the purposes of this section, that's not what they're doing.
Well, they're still being supervised. They're just operating according to the written instructions of the supervising veterinarian.
If there's a premises permit, they're in a hospital setting.
It does not say.
So we do have a motion and a second on the table for this item, and it is to amend 4840 and add, and the veterinary assistants may perform necessary and prompt veterinary care on those animals impounded by a state, city, etc. Any other comments before we vote? Ready for the vote? Will you do roll call?
I will. I know. And you didn't want to do pursuant to civil code section 1834.7.
Well, they did not amend that.
Do you want to ask for an amendment?
So would you want to amend that to add that pursuant to Civil Code 1834.7A2, which has the definition of an animal shelter entity?
Yes.
Good idea.
Okay.
1837, is that what you said?
No, 1834.7, A2.
Okay, that only provides for, oh, okay.
The definition of
Just
shelter.
yeah, all right.
Yeah.
Okay.
Which would then include the private shelter.
Uh-huh.
Yes.
Okay.
All right. Dr. Klingborg.
Nay.
Dr. Druses.
Aye.
Dr. Grant.
Yes.
Diana Woodward-Hagel.
Yes.
Dave Johnson.
Nay.
Jennifer Laredo.
Abstain.
Christy Pulowski.
Yay.
Yes or no?
Yay.
Okay, thank you.
I'm sorry, I always say yes. That's why.
Dr. Pollard
Yes.
and Dr. Sullivan.
Yes.
Okay, motion carries. So let us move on to issue number 2, controlled substances, the administration of pre-euthanasia drugs by shelter staff. The recommendation here was that veterinary guidance should be required for the selection and use of pre-euthanasia drugs. If controlled drugs such as ketamine and telazol are to be used, then a VACSP should be obtained. Discussion? Yes, Dick.
Yeah, I was thinking that if this is for euthanizing an animal, I think it should also be restricted to someone that has the euthanasia permit.
Question. Are there people that perform euthanasias in a shelter setting that don't have that?
No, but this is requiring them. So what I'm getting at is that you don't have a person with the veterinary assistance controlled substance permit doing the injection, and then somebody else has to do the euthanasia. I think the same person should be having that task.
So I think the question here is, so you want that individual to have both the veterinary assistant controlled substances permit plus the euthanasia certification?
Yes.
They wouldn't have to have, if they're already certified as a euthanasia technician, they wouldn't have to have a VACSP.
If they're using a controlled substance, they would.
Substance they do.
Well, we talked about that at the last meeting where Tara went through and did a legal opinion, and because there's a carve-out for the euthanasia technician, they wouldn't need a separate VACSP.
I thought that was only for the sodium
Right.
orbital.
It
We're
was.
talking about the other controlled substances that are being used
right.
now.
I understand.
They use telazol to get them sleepy.
Okay, separate
Right.
controlled substances.
And I also just wanted to clarify, in my reading of 2039, the term certified isn't used. It's just you have to have completed the training. So there's no such thing as a certified euthanasia technician. Anyway, I just wanted to clarify that. But So 2039 exists really for the situation in which you don't have a premises permit and you have shelter staff who need to administer sodium pentobarbital, and there's no RVT or veterinarian there to supervise. But you could, I'm assuming, you could be a staff member in a shelter with a premises permit and not have undergone this training and administer sodium pentobarbital to euthanize an animal. So this training is only required for people who aren't being supervised.
That should be true.
Okay, so, but then those people would have to have a VACSP. I'm just, and then that would go to what your request that if somebody is going to administer a pre-euthanasia sedative, that it be somebody with a VACSP, not somebody who's administering sodium pentobarbital under 2039.
Correct.
Okay.
So where do we want to state that in these?
I have no idea.
We got it in one thought.
Well, we don't have to make that decision right now, but we can agree that we think that that individual should also have a VACSP. Now, they are at that point supervised, are they not? If they have a VACSP, is they're not a supervising veterinarian? And of course, they need to have controlled drugs, a veterinarian to get the controlled drugs to begin with. But anyway.
I think you can have a separate permit to get the controlled drugs. Are you talking about sodium pentobarbital
No.
or other drugs? Yeah, so
Other
they
drugs.
would have to have,
Right.
DEA.
Yeah.
Right.
But
So that's the recommendation that's in the document.
right. Recommendation is that controlled drugs are to be used. A VACSP should also be obtained. And Dick has said, I believe, that that is also the same individual that has completed the euthanasia training.
Yes. Because, well, there's going to be supervision there, but a person who is doing the euthanasia may have the permit, but may not be an RVT. So I'm saying if they're not an RVT, they need both.
Or a veterinarian.
Or a veterinarian, they need both the permit and the euthanasia training.
Is that necessary? Can you not have Jane that has the VACSP and Fred who has the euthanasia training, and the two of them can form a team and do that?
I thought the euthanasia training is in a scenario where there isn't a veterinary oversight or an RVT there. I'm not sure. That's what I thought I just heard. Let's look at it.
Yeah, I didn't think you had to have this.
They may not need to be linked.
I don't know.
Is it necessary to link the two, or can we just make a recommendation and figure out where we want to put it in ranks later about controlled drugs and the VACSP should be obtained?
I'll go with that.
I'll second it.
Other discussion? Discussion from the audience? We will call for the question. The question is a recommendation that if controlled drugs are to be used in euthanasia within the shelter setting, then a VACSP permit should be obtained by the individual administering the controlled drug.
So here's my problem with you calling a motion for this. This was already clarified in Tara's legal opinion, that if you're using anything beyond the sodium pentobarbital, you need a VACSP. So this isn't a motion, this is how the current law is written.
Okay.
If you want to do something different than this,
No action.
then you would be changing statute, changing regulation, or doing something other than that. So if you're using a controlled substance as a pre-sedative to euthanasia, you have to have a VACSP. That's not by motion of this committee. That's the way the law works.
So can we just change the motion that we agree with Tara?
I don't think you need a motion.
Okay, so I will rescind my motion because we're just agreeing with the law as it exists.
Okay.
I'm sorry, if I could make a quick comment on Business Professions 4827 provides for the administration of sodium pentobarbital for euthanasia by shelter staff, free from the veterinary premises permit.
Yeah.
I think it's important to recognize that both for the safety of the personnel that are involved in handling aggressive animals potentially, as well as in order to effect a humane euthanasia for many of the animals that we deal with, pre-sedation of those animals is an essential step. And that with regards to the administration of a sedation prior to euthanasia, if that is the sole reason for possessing and administering these controlled substances, it would seem logical to me that that be included in that exemption, that the pentobarbital is exempted, which is actually a schedule above the drugs that we're talking about generally in terms of their control level, and is a more substantially restricted drug. And it would make sense that if we're making an allowance for pentobarbital, that these pre-sedatives drugs should also be included in that exemption. Otherwise, again, if you have a facility that has no veterinary premises permit and cannot acquire those medications, they're left with just simply pentobarbital, and that may not be safe, it may not be humane. So I'd encourage you to think about actually allowing that exemption for that specific function.
I know how would you get the drugs?
The problem with anything we discuss with the VACSP is that was mandated to us by the legislature. We don't have any choice. They told us, if you have lay people handling controlled substance, you're going to need to give them a permit. So that came from the legislature, and I don't see any way we can carve that out without going against the directive of the legislature.
Yes. Also, in order to have ketamine, you've got to have a DA license or somebody orders it for you. So somebody that has a DA license, however you schedule it, 2, 3, or some of that scheduling seems a little nonsensical these days with marijuana equivalent to heroin and just the way it is. But either way, you'd have to have a DA license. So I agree with Dr.
Quite
Sullivan.
honestly, with the epidemic that we are experiencing in our country, I just do not see that we are going to get exemptions right now. I do not see that that's going to be something that they're going to do. The DEA.
Well, I'm curious, how would you get them if you didn't have a veterinarian involved? How would you get the controlled substances?
Well, again, the pentobarbital is being acquired with a DEA license. It's currently restricted, so it would be the same acquisition pathway. What I'm talking about is the requirement for a premises permit does not apply to pentobarbital injection for euthanasia. And so solely for the administration of these sedatives in conjunction with the administration of pentobarbital and in conjunction with the performance of euthanasia, that's where I'm asking to consider an exemption from a premises permit requirement.
But I don't believe a VACSP is tied to a premises. It's an individual who's gone through life scan. I mean, I don't think that there's a...
You do need a license. Yeah. I think those are two separate issues, though. The premises permit is one issue, but then acquisition of a controlled substance is separate and apart from that. So in order for the sodium pentobarbital to be acquired by an RVT, we had to have an exemption in the federal law, so that the federal law has a category, and I think it's called shelter something. It has a weird name, shelter, mid-level practitioner, shelter medicine, or shelter staff. But that we had to handle, on a federal level as well. So it's not that the board could say, okay, you're exempt because you're not under a premises permit to obtain controlled substances for the purpose of pre-sedation. Those are kind of two separate issues. There's a premises permit issue. I see how they're intertwined, but there's a permit issue, and then there's the obtaining and administering of controlled substances, which...
On top of that, the VACSP is separate and apart from the sodium barbital in 2039, which was mandated via 4827 subdivision D, which is completely separate. That's the ACO can obtain the sodium barbital. It's late in the afternoon. So, you know, that also would have to be a legislative change plus the DEA recognition that you can't just, you know, shoot an animal full of the sodium pentobarbital. You also want to do the pre-sedation, but you're going to have to get the exemption for it somewhere else. It's not just a 2039 issue. Anyway.
All right.
Yeah. Many layers. That's the point.
Could you theoretically have a veterinarian with a DEA license at an animal shelter without a premises permit?
Yeah.
Yeah.
So then, I mean, wouldn't that be a pathway to obtaining the pre-euthanasia sedatives?
They got a permit.
Right.
But you'd have
it.
it.
Administering would still have to have the permit.
Yeah.
The veterinarian administers, there's no problem, but the
So,
person handling the.
yeah, you would need a DEA license at the shelter.
Right.
But you wouldn't, but that's separate than needing a premises permit.
Well,
For the
consider-
purpose of controlled
The
substance.
permit goes with the veterinarian, not the location.
The
You
DEA.
can do mobile,
The DEA permit. Registration.
So if theoretically a shelter, so if pre-euthanasia sedatives were added to 4827 and wrapped in with sodium pentobarbital, and there were a veterinarian who was willing to buy the pre-euthanasia sedatives, the shelter could use them at their location without having a premises permit there?
But you don't have anyone who's authorized to administer those controlled substances without supervision. So there's
Under
an
federal
exemption.
law.
Well, right, there's no carve out in DEA registration for anything other than sodium pentobarbital as a mid-level practitioner shelter staff.
Okay,
So there's a definition of that for sodium pentobarbital.
Okay, and so you're saying the only reason that 4840C works, which gives the specific authorization to RVTs to apply for registration from the DEA,
Yeah.
is because the DEA has an existing
Right.
regs or law that allow that
So our statute was written.
after.
No,
Oh.
I think how it worked was our statute was written, and then we had to confirm with the DEA that this mid-level practitioner qualification based on the training and whatever was acceptable. So it was written, and then there was negotiation with the DEA in terms of creating a title and a registration. So it is led by state law. The statute leads that, and then you work with the DEA on creating the mid-level practitioner, because there's other professions that have a mid-level practitioner DEA license. But it's all based on authority, scope of practice, training, so there's several layers to that, right? So my point today is we couldn't just exempt this, that there's more to it than that. We couldn't just say, because you can issue sodium, or because you can administer sodium pentobarbital, you can now administer acepromazine, ketamine, tilazol, whatever the list is, because we're going to essentially exempt those controlled substances from needing a permit. There's essentially a process, and you would need a DEA registration category that would be created out of that. And if that's something that perhaps the shelter community wants to do, I mean, there's nothing stopping you guys from pursuing a legislative solution to this. I just think you need to be aware of the layers and the exempt classification or registration classification that you would have to then get from the DEA to be able to administer those drugs, whether it be under supervision or not.
Thank you.
I just wanted to remind you that a VACSP requires a licensing manager. That they can acquire the permit, but it's not able to be used unless there is a licensing manager attached to it.
Right.
So that situation has to be solved in tandem.
I believe the DEA registration is about the RVT and VA operating under the veterinarian's DEA registration.
I'm talking about the
not
controlled drugs.
premises permit.
The controlled drugs prior to euthanasia. We were talking about requiring a VACSP for the person who was accessing controlled drugs as a pre-drug prior to euthanasia.
I thought the concern was the ACO administering the sodium pentobarbiturate. And the ACO needs the pre-sedation. How did they get it?
Who's the ACO?
Animal control officer. It's not necessarily, it's shelter staff. It's not necessarily the ACO. So it's just shelter staff in general being able to administer a pre-sedative prior to euthanasia. So Nancy, we're aware that the VACSP requires supervision. We're all
not just
aware of that.
supervision, it requires a licensing manager. Because every supervising veterinarian is not a licensing manager.
Right. So, at this stage of the game, where are we? I think where we understood it was that it was current law, and yet there's a conundrum here in that if it's current law that you need to have a VACSP in order to have a controlled substance administer this prior to euthanasia, that VACSP only happens if there's a licensing manager, and if there's a licensing manager, it means there's a premises.
Mm-hmm.
And there was nothing that said that this was necessarily happening on a premises, so I'm not sure how the VACSP is actually mandated if there's not a premises. So maybe what we need to do with this particular action item is have legal explain that to us on another day, because it's complicated.
I don't think it's complicated.
Okay.
If they're going to use that product, they have to have a premises permit and a licensing manager.
Okay. There you go. So, simple.
And really, it's more about the storage of the drug.
That's everything.
Well, it's the storage, but the supervising veterinarian is a separate issue from the licensing manager. It is, because under 4836.2 VACSP, they're just operating via the veterinarians, the supervising veterinarians' DEA registration.
Right.
It's not about the licensee manager's DEA registration per se, but where is the VACSP holder obtaining the substance? From the facility,
But
the
the veterinary,
premises.
whatever that was, controlled substance practice thing that allowed us veterinarians to carry controlled substances and administer them at sites other than our premise would, in this case, mean that the veterinarian has to be there. He can't leave the drug there and go somewhere else, and at a later date, staff use a pre-mixed cocktail.
Well, it's based upon the supervising veterinarian's principal place of business. They can travel with the drug.
Yes, he can travel there.
Right.
He can administer them, but he can't leave them there for a later date for the staff to use when they see fit.
No, because that gets back to the whole purpose of the Controlled Substances Act. We're trying to make sure that everybody knows who's got access to the drugs. And if he leaves it at a shelter, we don't know who's got access. Yeah.
We had that issue. There was no veterinarian on Catalina Island, and their choice with LA County Sheriff was to either shoot an animal or whatever they needed to do, or I had a permit and had one of the sheriffs take the special, I forgot what it's called, so the euthanasia training. They took the euthanasia training, they logged it, they brought it over to me, I logged it, and we had that go through legal, and they said that was fine to do, even though I wasn't on Catalina Island at the time.
But that's the euthanasia solution. I think that carve-out that we've agreed is something completely different than any controlled substance used in a pre-mixed cocktail for sedation.
We're talking about that. No, you're right, it is. Yeah.
So can I ask a question? I think Erica and Eric, when you talked about the request of your respective organizations, you did not want an exemption from the premises permit for the purposes of being able to administer these pre-sedatives. Your organizations both felt that you wanted VMB oversight for this issue, correct? Okay, so this wasn't about getting an exemption from the premises permit, right?
Correct.
Okay. I think so. So that's where we're starting to get. We're mixing up the issues. This particular issue is about. Go ahead.
I'm sorry, I know this is complicated because depending on, like, there are all these different moving parts, and I think I just want to get back to what our original intent is, and that's to ensure that that shelters that don't have RVTs and veterinarians on staff are able to provide certain basic healthcare services to the animals that come in. And how that's done, and whether it's done under 4827 by carving out an exemption, or whether it's by having a premises permit that allows for a shelter director rather than or an RVT rather than a veterinarian, I think that's, we're open to whatever. We just want to make sure that these shelters who don't have access to veterinarians and often to RVTs still have the ability to care for the animals that come in. So I would say that we are not tied to a particular solution, and we're not wed to any one way. We just want to do whatever makes sense within, balancing all the interests to ensure that the animals are able to get the care that they need, in the interest of the animals and in the interest of the public.
And that sounds very good.
I know, and so while it sounds like we're talking, and so
I think though now we're getting down to the specifics that you've asked us to address. And the first was the veterinary care on intake, and that's what you just explained. And I think we're trying to work through some statutory solutions for the veterinary care on intake. The second issue was this pre-euthanasia drug stuff. And my understanding from your initial comments was you were not looking to have premises exempt from the premises permit, or shelters exempt from the premises permit, if you were going to have staff handling controlled substances via a pre-euthanation cocktail. Is that true?
That's true if we could have a premises permit that allowed for a shelter director to be the manager licensee.
So if I might jump in on that, I think currently there is the exemption for the administration of pentobarbital without the premises permit. And I would posit that in this context, I would advocate for these specific controlled substances for this specific function to be exempted from the premises permit as well, if nothing else changes specifically.
You can't do that, the DEA won't let you do that.
Right, so I'm just, to your question. So to that extent then, I don't think that there's and I think actually some degree of oversight and regulation is appropriate, and I think we do welcome that. Just trying to find a way to make that work for particularly small shelters that really don't have these relationships. So going to, as a potential exemption or a potential solution for that premises permit to a shelter director. And I understand the conflicts that you mentioned with regards to not having direct oversight of that individual or essentially a regulatory authority on that individual.
Right.
Certainly just the revocation of that permit and that ability to function, I think, is some degree of a stick over that agency, as it were, to ensure that they remain in compliance as well, because those are functions that they really do need to continue to perform. But there's not an individual that you are licensing, that is correct, yeah.
Just hypothetically, to that point, if you had a shelter director, let's just say you're a shelter director, we come out and inspect your shelter, and you violate the minimum standards, who are we going after?
Well, I think that you have, as far as an individual personally responsible, and to be honest, I don't have the in-depth familiarity with all the regulatory codes as to how individual responsibilities are set up within this, and I do understand the licensing issue, and that is sort of the tie-in to where the regulation occurs. The permit that's issued for the facility, I think, is essentially both the carrot and the stick at the same time, right? If a permit is required in order to be able to administer vaccinations, in order to be able to euthanize animals, in order to be able to use pre-sedative and do some of the flea control and some of the other, core shelter functions that those agencies which have a legal obligation to take in these animals and provide care for them and do, you know, basic care, that permit that facilitates their ability to do that is the carrot in terms of coming into compliance and being able to establish the conformity with the regulations or the standards. The stick is the potential revocation of that permit. So I think it's the permit essentially that is
so you understand
in question, not the license that's in question, if that makes sense.
It does. I understand theoretically how that makes sense. The problem is how it really works is the permit's tied to a person. And without a person, the permit doesn't exist. And if we were to try to license, not even license, permit an unlicensed individual, essentially the board or the state has no recourse. Because if, in fact, someone who is a managing licensee of a facility violates the minimum standards, the consequences are revocation of the license. The consequences are we could, in fact, shut down that facility. We don't have that authority over an unlicensed individual. The most we can do in a situation where we walk into, let's just say, a grooming parlor, they're practicing veterinary medicine, there's no licensed individual, is a citation and fine and turning it over to the DAs. So from the board's perspective, there's a lack of connection between the enforcement of the minimum standards and a layperson who's responsible for the enforcement of those minimum standards.
But couldn't you revoke the premises permit so that the shelter could no longer engage in this healthcare?
You can revoke a premises permit, but the revocation of the premises permit is tied to the revocation of the license typically, or the person whose license basically initiated the revocation of the premises. And Bonnie knows this all too well.
But for an animal shelter, could it look different than it does for?
I'm struggling with how. I'm not saying absolutely not. I'm struggling with how the Veterinary Medical Board would have the authority to regulate a setting that doesn't have a licensed individual involved.
Nothing personal at stake.
Unless you're creating a new license type. So let's say, for example, your proposal is create a new license type that is a shelter director, right? That individual becomes licensed under the Veterinary Medical Board and has a set of requirements or pre-qualifications they have to meet. That individual then has a license. That license is then tied to a premises. That would be kind of the scheme that would have to be built in order for the board to have authority over the individual that's responsible for the minimum standards. I can't quite today figure out how we could create a structure where we essentially are licensing, or we have oversight over an unlicensed individual. And I think that's where I'm struggling. And
I keep going back to, the Food and Ag Code, because you keep reminding us that it's a mandate. These shelters have to accept these animals and they must provide care pursuant to statutory requirement. Where's the requirement or exemption under the Food and Ag? Because they're effectively what created the situation. It's compounded by the Practice Act, which requires, licensee managers and people to be tied to this stuff. Is the better solution in the Food and Ag Code, which effectively could mandate that every municipality provide a licensee manager / supervising veterinarian for every location in each county, and push it back on the municipalities. Because if the legislature is saying this is important enough, then they should be also providing or finding a way or a mandate to fill that void. Because there's a void here, and it's oversight of duty of care and appropriate practice of these veterinary healthcare tasks, which we don't really know, or are they being performed appropriately if there's no supervising veterinarian? Anyway, I keep getting back to Food and Ag. Yeah. If they wanted to mandate this, then they should also be presented with this problem and solve it. Because waiving the premises permit licensing manager does not do anything for the Veterinary Medical Board, which has a mandate to protect the public. So how do we do that, waiving standards for facilities and, you know, appropriate practice?
I would say the intake requirements and obligations for animals at large, injured ill animals from the public and so forth, those are historical and very long-standing requirements that have been there. The suggestion that you have, it makes sense, but it does create a mandated function on these local governments that they're going to have to perform. And that does get us into this idea of a unfunded mandate, and as to whether or not that could actually be brought into existence. And that I think is the hurdle on the other side is with any number of ideas that have come up over the last several years in any number of different areas, the proposition of an unfunded mandate just simply doesn't go anyplace, because we're required, or the state would be required then to reimburse the local governments for the cost of contracting a veterinarian and so forth if you created a new unfunded mandate. And I think there's just a really fundamental difficulty of getting that sort of
and yet there's a cost to providing animal services at each location. So, you know, do we want to mandate crappy care?
That was going to be my point, that I could hardly contain myself. So, you know, where the rubber meets the road, and that's at the local level. And so what happens is that when requests for proposals are sent out to perform animal control and sheltering services, it's not a level playing field, because there are significant numbers of parties involved who don't have a veterinarian, don't even have an RVT, obviously they don't have a premise permit, and they underbid those organizations that are trying to raise the standard of care and the animal, protect the consumer, protect the animals, and they can't do it. I can cite examples where an organization would charge a city $35 per impound, yet has none of these, no RVT, no premise permit, no nothing. And another organization that bid on the same contract was $135. Why? Because they actually employed people who gave a damn about this stuff, and it wasn't after the money. That's what it comes down. I'm afraid to say it. I know I'm on TV.
Hasn't stopped you before.
I know.
Bonnie.
I just have one additional comment, and I don't really have a dog in the hunt specifically, but for a client, I had the opportunity to look at all the practice acts in the country, and there aren't that many premises permit states. The vast majority of the states are not premise permit states. So it would be interesting to look at how those state veterinary medical boards control those practices. I have no idea. I just was tasked with finding out which ones were premise permit states. But it might be interesting to know how they control those. And I'm not suggesting that this is good or bad, but it would be interesting to know how they control those facilities in their state if they don't have permits and they don't have a veterinarian with his name on the permit.
So they may not have an actual, and I learned this at the AAVSB, they may not have actual premises permit category, but they have hospital minimum standards. And not all states, but some states. So it's still tied to the veterinarian to maintain minimum standards in the hospital. Even though there's not a separate premises assigned to that location, there's the requirement that a veterinarian uphold the minimum standards of the facility. So they don't necessarily license the facility, but the veterinarian, wherever they practice, has to comply with hospital standards. And you're right, there are not as many states that have a premises permit as there are that don't have a premises permit. Most states are moving towards hospital minimum standards, and in fact, often California is called upon by other states to supply our minimum standards to other states so they can use them as a model. So I don't know if it's just the license of the veterinarian is on the line, if when you show up at their facility, their hospital standards are not in compliance. That would be my guess.
Yeah, because in the permit, in the PC, what we call PC states, where the professional corporation has to be a vet, then obviously they go after the PC. And then in the permit states, they go after the permit holder. But there are some states that fall in the cracks that are not specifically owned by professional corporations and are not. So you're saying in those cases, they just look at the vet who's there. Okay, that makes sense.
That's my understanding, yeah.
Okay, so we're going to take a break here for 10 minutes. I'm going to have those of you that have flights or need to leave, let me know during that break so I can try and organize the last segment of the day.
Yes. I have to babysit him.
Someone's fishing out of your pocket. What? Fishing out of your pocket. Oh. So when you
All right. We are on a minimum standards and protocols for shelter medicine. So we've been discussing agenda item number 2, controlled substances in the administration of pre-euthanasia drugs by shelter staff. And have had a lengthy discussion, and these issues are all intertwined and complex, and we're finding other issues bubbling to the surface as well as we continue to talk about it. So what we need to do is actually, I think, take some directions at this stage. I'm not sure that continuing to move through these one by one is as effective as we had hoped it was going to be.
So at this point, I think that what we thought we accomplished with this document that we presented to the MDC was some problem solving. But from what I hear today, I don't think we've achieved necessarily bridging that gap. I think there's still a lot of work to be done. I think that I've learned more today about some of the primary issues that are preventing the shelters from being able to provide the necessary services. I think you've heard from us that we have some very explicit, if you want to call them mandates or oversight, that we can't, those are hurdles that we necessarily can't overcome. So we're going to have to find common ground somewhere. Perhaps it would be a good idea to have a working group meeting with SHAC and CAPTA explicitly, so that we can work in more of a kind of a task force environment, if you will, outside of a public meeting where we identify the issues, we look at the hurdles that we're facing, and try to strategically come up with a way to find some middle ground. As Dr. Klingborg said, I don't think we're going to be able to achieve that today because we still seem to be really far apart on some of these major concepts. So that would be my proposal. That would require a direction from you as the chair, Dr. Klingborg, to assign members to meet with SHAC and CAPTA explicitly, and perhaps the associations, to the extent that the associations need to be involved in these discussions before they come back to the MDC.
And would the MD Legal be able to be part of that meeting? Yeah.
Yes. Yeah, I'm not a member, so.
Right. So I would like to form a subcommittee to continue to look at this issue. That's a 2-member subcommittee by law with SHAC and with CACTA. It's up to you two to figure out who you're inviting to it. That's not the 2 members of the subcommittee. So all the allied industry, stakeholders, whatever, it's not up to me to tell you who to invite, okay? But that would be something that we will do. I will talk with our current subcommittee members and see if they're willing to continue on that. And if they need a break, then we'll assign somebody else. But we will move forward. I really hope, because this is on our plate right now, that we can actually have something substantive by the February meeting so that we can continue to press forward. Because otherwise, a few things are going to happen. One is we're going to lose momentum, and the other is that a number of members of this committee are terming out. And so all the institutional memory that has been built up on this issue will be gone if this thing doesn't get handled here within the next couple of meetings. So there is some pressure to try and push forward. Is that, any questions, any concerns? We're good on that, gang? All right. So the next agenda item, and thank you everybody for all your work. I mean, honestly, it's a good discussion, and obviously it's complicated, and we want to do it right because it helps animals, and it's a good thing. Agenda item number 7, discussion and consideration of the California Veterinary Medical Association's proposal regarding minimum standards for alternate veterinary premises / practices. 2 years in the making. I don't know if Val and or Grant, you want to speak to the document. Be happy to have you kind of give us an introduction. And we're really just going to be introduced to it today. We're not going to be talking in depth because there are a lot of moving parts on this one as well. So this is the getting to know you phase of your work product.
I'll be brief. And I think our letter is pretty self-explanatory. I tried to put everything in there that gave the history of the premises task force, which we were asked by the Veterinary Medical Board to form. We gathered a great group of experts of all different facets of the veterinary profession. We worked on it for 2 years. We had 7 meetings, 7 very long meetings, including the shelter part that we submitted to you last year. I think that when you look at it and you compare it to the Practice Act and that section, you'll notice that it looks quite different. We went down a few roads and then we went back in a different direction. We started out and proceeded with the same general format of having one major section that had as much in it as you could possibly imagine for every practice type, or premises, I should say. And when we got to our 6th meeting, we realized that we had a really long section and a lot of smaller sections, and that if you were a practitioner and you looked at it, you'd be flipping pages back and forth and not really feeling very clear on what your requirements were, depending on what type of practice you had. So we took a step back and we decided to, even though it's lengthy, make each what we then decided to call facility and or practice type, realizing that not everything is a fixed premises. Some are actually a type of practice. And we went ahead and made each section independent, except for a very short introduction that applies and cites other sections of the Practice Act. And when we looked at that in our final meeting, we really felt that helped licensees really understand what is expected of them. And you may find that some parts, when you look at it, you might think, why did they leave that in there? But we didn't feel that it was our place to take out some of the general requirements that were for every single practitioner. What pointed out to me today was the fire precautions. Yeah. And how that applies to a home.
Or an ambulatory practice. Yeah.
Right, because you don't have any control over somebody else's home. So there are a few things I think need to be looked at still. We just didn't know that it was our place to remove some of the more general requirements that were in the Practice Act and have been in the Practice Act for a long time. So I think there is some room to relook at all of it, but I'm hoping that you know, 95% of it is, I went from 90 to 95% in the last 10 minutes, is really good work. I think the task force debated, discussed, argued every word in this entire section, multiple sections that we've given you, and really put their hearts in it. And just pleased to put it forward, and now it's yours.
Okay, thank you. Any questions for Val at this point? Any discussion? Thank you, Val.
Sure.
Yeah. Any discussion? We need to, at this point, this needs to also go to subcommittee. It was one jigsaw puzzle that got disassembled and reassembled, and pieces that were in the upper right-hand corner are now in the lower left-hand corner. And so we need a subcommittee to try and help sort that out and tell us a story that makes sense as we look at this and how things have changed and are refined, so that we can all understand the document, I think, would be the ideal, rather than us all trying to write as a group something which I think is the worst kind of torture. So I would like to appoint a subcommittee to look at this and come back at our next meeting, and we can really dig into this as well. And a Rhinoceros told me that Doctors Grant and Sullivan were interested in potentially doing that. Would you be willing to serve on that subcommittee?
Is the meeting at the local pub?
If not, then it will be after. Yes.
Be a yes.
Okay, great. Any discussion from the audience at this point on this particular agenda item? Obviously very premature.
Can I ask a question procedurally?
Sure.
So, or more in preparation for the subcommittee meeting, there's work that, would you like staff to try to provide you a roadmap? Would that be helpful? Strike out and underline, the typical format is not going to be helpful for you. I can guarantee you that much.
Let us look at this, see if we can reconstruct some of the questions, things that were changed, do a red line copy, and then maybe we can send you what we have. And I don't know if you want to involve CVMA looking at it also, a couple more eyes look at it, make sure that we're all on the same page.
Okay. Just if you need something, let us know sooner rather than later, so that we can, I don't want to delay your work.
I've also got some comments and questions on the language, so I'd love to be able to participate somehow.
Can we directly contact legal, or do we need to go through you?
You can contact legal counsel.
Okay.
I think the first thing that, as I look at it, is identifying what is existing and what still is there. And that's just a matter of going right down the list. And then that'll identify what changes are there. And I've done that twice already, and I think that's going to be a very small number of changes, and that's what we can then focus on.
Yeah, as I thought about how to create this so that it showed that we weren't actually, removing language or changing language, but moving it from one section to another, was simply creating comments around each section. How many of the subdivisions were actually taken from the general minimum standards? How many of, which ones have been changed and why? And that was, in my mind, the only way to really capture that so much of the language is existing language, just moved and replicated. And that there are some exceptions to that. And really what you're focusing on is the exceptions. So, if I can help.
And it's kind of like Alan said about fire suppression with a mobile practice. It's the same thing with the ability to render radiographs on a mobile practice. It doesn't happen. And part of that two-sentence structure, the second sentence got taken out, and that's the whole point of what needed to stay in. So
But it was removed for a reason, so we have to put that reason in there. We have to have, that would be a good side note.
And there is some changes, Val, identify, yeah, okay. So there are other changes that can be incorporated.
Okay. Other comments, discussion on agenda item number 7, premises? All right, we're going to move to agenda item number 8, public comment on items not on the agenda. Do you have any comments from members of the public? Hearing none. Agenda item number 9. Let's see what we need for this. We have our priorities here. We do. So future agenda items and next meeting dates. Future agenda items.
So under, did we put in there and just declare those?
I don't think so.
Thank you. You know where they are. They're in the board.
So we've got our existing priorities, which are a complaint task force. I'm trying to think of where are we with extended duties at this point. We do have some discussion points with extended duties that came up today. We will continue with the shelter issue. Student exemption, we have language that we have voted on that will be presented to the board. They will be discussing, not at tomorrow's meeting, but at the meeting in February.
No, the student exemption is on tomorrow's agenda. It's
Oh, it
part of
is.
a legislative initiative.
Oh, okay.
Yeah.
Okay. So we will be discussing today's language tomorrow. Obviously, the premises issue that we've just formed a subcommittee for, I'm not aware of any other items at this point coming from the board, but there's always tomorrow. Did I get everything?
Yeah. Just to clarify, with the discussion on extended duties, I think the subcommittee agreed to look at section 2035 in terms of the supervision roles and how we may be able to craft the supervision language to identify those high-risk invasive procedures and the delegation surrounding high-risk and invasive procedures.
Yeah, I have actually, define, restrict, elevate invasive, make supervision duties more extensive, like there's question marks, provide more clarity, what does invasive mean, competence level, that's what I have for my notes.
Okay, and then our next meeting date, February 20th in Sacramento, and then following that, May 22nd, location to be decided. Anything else?
I don't think so. I think we're...
Okay, a motion to adjourn would be welcome.
So moved.
Sorry. We are adjourned. Thank you again.